This virtual session of the Appellate Division, First Department, is now in session. Good afternoon, ladies and gentlemen. My first order of business will be to call the calendar. When you hear the name of your case called, please respond with your appearance, and I will confirm to you the time that's been allotted for your argument. People versus Lewis Ailman, submitted. Villar versus Nisha.
Ryan Goldstein for the appellant. Good afternoon, Your Honor.
Patrick Lawless for the respondent. Good afternoon, Your Honor.
Good afternoon. The appellant has 5 and 2. The respondent has 5. B&N Children, submitted. Damon Douglas Company versus Arch Specialty.
Good afternoon, Your Honor. Joseph D'Ambrosio for the appellant.
Good afternoon, Your Honor. Jeffrey Beer for the respondent.
Good afternoon. The appellant has 5 and 2. The respondent 5 minutes.
Thank you, Your Honor.
Sage Systems versus List is submitted. People versus Terrell Green is submitted. JHAC LLC versus Advance. I believe that's withdrawn. No one's saying it's not, so that's how I'm going to mark it. The next 2 cases are Granite State versus Moklum, submitted. Alberto versus DeSano Demolition.
Christine Kasha for plaintiff appellant respondent.
Andrew Kolowitz
anybody
for
else?
DeSano Demolition respondent.
Richard
2 other
Gibraltar
parties.
or respondent, Nikos Construction.
All right, we haven't been able to make contact with the co-appellant here. Let me just indicate that the plaintiff appellant, you have 5 and 2. The 2 respondents who are present, you each have 5. If the co-appellant shows up, we will accommodate them for the argument. Otherwise, we're going to go forward without them. Moray versus Hawa, submitted. People versus Anthony Richard.
Good afternoon, Your Honor. Mark Zeno for appellant.
Good afternoon, Karen Schlossberg for respondent.
You each have 6 minutes.
Your
David
Honor,
Berg and Associates versus Wexler.
Yes, good afternoon, Your Honor. Michael Fay for the appellants.
Good afternoon, Your Honors. Steve Levitt for the respondent.
All right, you each have 5 and 2 for rebuttal. Dinarti Galato versus Schweitzer.
Randy Mastro for appellants, the Schweitzer defendants, Your Honor.
Good afternoon, Your Honor. Georgia Winston for the appellants, Garcia Law Firm and Renee Garcia.
Good afternoon, Your Honor. Clifford Robert from Robert & Robert on behalf of the respondent, the Gennardi Law Firm.
All right, and the 2 appellants each have 5 and 2, and the respondent, you'll have 5 to respond to both. People versus Rakeem Douglas.
Good afternoon, Your Honor. Katie White, legal intern with the Office of the Appellate Defender on behalf of Mr. Douglas.
And good afternoon, Your Honor. Stephen Kress on behalf of the people.
All right, appellant, you have 7 and 2, and the people have 5. American States versus Graphic Arts.
Good afternoon, Your Honor. Howard Edinburgh for appellant Nova.
Good afternoon, Your Honor. Marshall Potashner for the respondents.
All right, good afternoon. The appellant has 5 and 2, the respondent 5. Leopold versus Dabakarov.
Good afternoon.
I'm sorry if I mispronounced that.
Dabakarov, Your Honor. Good afternoon, Your Honor. Thomas V. Juno Jr. for appellants.
Good afternoon, Your Honor. John O'Brien for the respondent.
All right, appellants have 5 and 2, respondents 5. Napoli Skolnick versus Greenwich Insurance.
Good afternoon, Your Honor. Daniel Goldberg of Offit Kerman for the plaintiff appellant. And I've got Megan Finnerty here with me, who I'm moving to be admitted to argue the case.
Good afternoon, Your Honor. Megan Finnerty from Moffitt Kerman.
And I'm sorry, we weren't aware of any pro hoc vice on this.
Yeah, the motion was submitted. Yeah, the motion was definitely submitted quite a while ago, actually.
Okay. And she's Ms. Finnerty, you're from out of state?
Yes, Your Honor. I'm barred in the Commonwealth of Pennsylvania.
Okay. Thank you. All right. We'll grant the motion. And the respondent?
Good afternoon, Your Honor. This is Sanjit Shah for the respondents, Greenwich Insurance Company and Hudson Excess Insurance Company.
All right. The appellants have 5 and 2, and the respondents have 5. Finally, we have Gums versus MTA Bus Company, and that is marked submitted. Let's start with the first case on the calendar, Villar versus Nisha.
May it please the court, Ryan Goldstein for the appellant. Your Honor, appellant seeks to reverse the lower court's decision to grant the respondent's motion for summary judgment. We believe that the lower court erred in several respects with regard to the deciding of that motion. Just to give a little bit of background.
I think you can assume, Mr. Goldstein, that we're familiar with the case. We've had the briefs and the record on appeal. And since you have such a short amount of argument time, I would urge you to proceed right to your important points.
You got it, Your Honor, will do. So, Your Honor, the lower court disregarded the expert exchange as well as the supplemental bill of particulars that were served on the respondent pre-note. And the court did that by determining that in order to supplement the bill of particulars, we needed leave of the court, which is in violation of 304, which is inconsistent with CPLR 3042B. These were pre-note exchanges. In addition, respondents did not reject nor seek to preclude or seek a protective order. Rather, they filed a motion for summary judgment 3 months later and did not address these at all.
Mr. Goldstein, let me ask you a question. Does it matter in this case that in the deposition of your client, which took place before the supplemental bill of particulars and the note of issue, the theories of liability that were put out in the expert's report were not, she didn't testify to them?
Well, she could not have testified to the theories of liability identified by the expert because experts would understand if there's non-uniform risers or poor lighting. What she indicated and testified and still remains her position that she slipped because of a liquid substance. Now that liquid substance.
Well, this is Judge Kern. Even if she could not testify about the risers being uneven, there's a certain way people would testify how they fell or what caused them to fall, or the manner in which they fell, which would be consistent with the theory of uneven risers. But she was very, very clear in her testimony that the only thing that caused her to fall was the wet condition, and she fell because of the wet condition. Did not even give the background testimony which would support an uneven riser theory. So how do you deal with that?
Your Honor, oftentimes a plaintiff does not know exactly what the cause of his or her accident is, but rather has an understanding. And in this case, she had an understanding that the liquid substance on the stairs created the slippery condition. She did not know that the non-uniform risers contributed to that condition being even more slippery than it otherwise would have been. And had the risers not been slippery, there's a question of fact whether she would have fallen due to the liquid or not. And that's why the lower court should have accepted the exchange and the supplemental bill of particulars. And at minimum, the lower court should have evaluated the reliability of the supplemental bill of particulars and the expert exchange, because ultimately the lower court decided that since that expert inspection was done 4 years after the accident, it was not reliable. But that is not what Oberler says. And frankly, the only reason why it took 4 years is because the respondent would not produce their deposition nor produce the site inspection until the court granted it only 5 weeks before the inspection took place. So it begs the question, if the lower court was going to reject as unreliable a site inspection at a hand, then why would the court have even granted the application for that site inspection in December 2018 for an inspection that took place January 2019. It really.
Mr. Goldstein, this is Justice Kennedy, and I would like to know, how do you address the fact that the plaintiff also testified that she was aware of any other cause of her slip and fall but the wetness, and also had indicated that she had no problem seeing the steps?
Because again,
as well as the fact that there was adequate lighting as well in the stairwell. She also testified to that as well.
Well, ultimately, Your Honor, Ms. Villar does not know all of the things that would have contributed to her accident. And today, to this point, she may not fully understand what the expert concluded with his inspection. That being said, even if the lighting did not contribute, although the expert says that it did, the non-uniform risers certainly were a contributing factor to a slip and fall, or to water being on a stairs. Water alone should not necessarily cause somebody to slip and fall unless there's contributing factors, and our expert deemed that there was contributing factors in this case that the lower court did not consider. And again, I repeat myself, I'm not sure.
I'm going to ask you not to repeat yourself, Mr. Goldstein, because you're out of time, but you'll have time on rebuttal. Let's hear from Mr. Lawless. You're on mute, Mr. Lawless.
Sorry about that.
No,
good
that's
afternoon,
okay. We
Patrick
have a
Wallace.
new reality.
Patrick Wallace for NYCHA. NYCHA demonstrated its entitlement to summary judgment through the affidavit of its caretaker who was on duty, that the day before the accident.
Your prima facie case, though, it was limited to the issues regarding the wet condition on the stairs, right?
Correct, and that's based upon the plaintiff's own testimony. She was specifically asked at a deposition, was there any other condition that caused you to fall? And she said no, other than the liquid. The only thing that caused her to fall was the liquid. And the other issue with respect to the theory of liability that the plaintiff raised in opposition to summary judgment was it's not contained in the notice of claim. So not only is it contradictory to the plaintiff's clear and unequivocal deposition testimony, it's precluded because it's not contained in the notice of claim. The notice of claim specifically says that the cause of the accident was the liquid substance on the staircase. It doesn't say anything about the risers or any structural defects. The plaintiff attempts to argue in his reply brief that the broad language in it somehow put NYCHA on notice, but that argument was specifically rejected by this court in the Lewis case, which is cited in my brief. Unless the panel has any other questions for me, I'll just...
Would you agree that the fact that the inspection took place 4 years after the accident wouldn't make a difference if the staircase was otherwise in the same condition that it had been at the time of the accident?
Well, there's no evidence that it was. And again, it took place four years after the accident. And aside from a conclusory statement by the expert that he looked at the photographs, there's no evidence that it was in the same condition as on the date of the accident. And again, the two insurmountable hurdles that the plaintiff has is that theory of liability is directly contradicted by the plaintiff's testimony, and it's not contained in the notice of claim.
Any further questions, colleagues? All right, Mr. Goldstein, you have 2 minutes.
Thank you, Your Honor. So with respect to the staircase, Your Honor, the burden would have been on the movement, the respondent in that matter, to demonstrate that the staircase was different when the inspection was performed than when the accident occurred. And that was not raised. It wasn't raised because they didn't even raise the issue of the expert exchange or the supplemental bill of particulars in their motion to begin with. In addition, as the court is aware, they also attended the inspection and did their own inspection. And they never exchanged the inspection report, and they never apparently generated an inspection report. So if their expert had any reason to believe that the staircase was different on the date of the inspection than it was previous when the accident occurred. They had ample opportunity to address that. In addition, Your Honor, in their reply to the lower court was the first time they raised any issues with respect to a notice of claim. They did not proffer any notice of claim defects or try to allege that there was any inconsistent claims between the supplemental bill of particulars and the notice of claim. That came for the first time in the response, in the reply, and the court should have disregarded it, Your Honor, as it was a new issue being raised for the first time in reply.
Thank you. Any questions, colleagues? Thank you both.
Be safe and well, folks.
All right, the next case up is Douglas versus Mount Hawley and National Union.
Good afternoon, Your Honors. Joseph D'Ambrosio for the appellant, Mount Hawley Insurance Company. We raised two issues on appeal, Your Honors. One's procedural, one's substantive. Both arguments are premised on the fact that the respondent, National Union, is a stranger to the Mount Hawley policy. I don't want to spend too much time on the procedural issues because our briefs lay out those arguments thoroughly, and we've always acknowledged that those procedural objections can be cured. We disagree with the trial court's cure. The trial court basically held that CPLR 3001 cures any procedural defects under Insurance Law 3420 and Lang versus Hanover because an insurer for one...
Can I ask you a question on the procedural? 3120 deals with a plaintiff suing defendants insured, right? Here we're talking about different insurance companies who the claim is that they insured the same risk, right? Aren't you allowed to do that?
This case is procedurally distinct, Your Honor. All the cases that have been cited to the court for this proposition about contribution are where the policies were issued to the same insured. Here you have a policy that we issued to Iron, the employer, and then you have a policy that was issued to an upstream party, Island. They're premising it on those contribution cases, but this case is different. They as a prerequisite to suing us for contribution, there needs to be a determination that the disclaimer was invalid. They're skipping that step and trying to combine it into one. And so our point is, why does an insurance company for a claimant, in this case Island, have greater rights than Island would have? Now here the distinction is, Island could have brought a claim against Mount Hawley challenging the disclaimer as a purported additional insured, but they didn't. We don't know why they didn't. Nor did Iron, the policyholder, challenge the disclaimer. So now you just have National Union trying to skip all of these procedural requirements because it would cause delay and they want to race to the end and then just say 3001 allows you to basically sue an insurance company, a tortfeasors insurance company, whenever you disagree with the disclaimer.
What's wrong with the argument that 3420 is inapplicable on its face because it just doesn't apply when it's a declaratory judgment between two insurance companies declaring their rights vis-a-vis each other?
Yeah, Your Honor, for that proposition, I cite to Lang versus Hanover from the Court of Appeals itself. It acknowledged in that decision, it references 3001 and when it can be used. And it specifically says, there is no dispute that the parties to an insurance contract, the issuer, a named insured, or a person claiming to be an insured under the policy may bring a declaratory judgment action against each other when there's an actual controversy. It doesn't say anything about a person who purports to be an insured's excess carrier can bring that claim before having to go through the same procedure. And again, we've always acknowledged that these defects can be cured, but our position is that you can't create an exception under 3001 that swallows the rule and gives insurance companies greater rights than the claimants would have themselves.
Mr. D'Ambrosio, I just want to go back. This is Justice Kennedy, because I just don't understand how either the Lang case or Insurance Law 3420 is even applicable, because that statute deals with injured parties. Here we have co-insurers, and certainly there is a final judgment in favor of Island against the co-insurer Iron. So can you just explain this to me? Because I just don't understand. That statute deals with the rights of injured persons. The instant matter deals with co-insurers. We know that neither Island nor Iron is the injured party here. So can you please, help me? How would this be applicable? Because I don't see it.
Yes, Your Honor. Again, all of the cases that have been cited to you involve situations where insurance companies who issued policies to the same policyholder are seeking contribution from one another, saying, you owe me because we both we issued policies to the same insurance company. Here, they didn't. The insurance companies did not issue policies to the same insurance company. Island may believe it has rights under the Mount Holly policy, but there needs to be a determination that there's coverage first. And they're skipping that step. They're saying, well, you owe it, and then you owe the coverage, and we're entitled to contribution. Our position is you can't have any better rights than Island, the claimant, who didn't even assert claims yet. And again, we've always said that these issues can be cured, and because of the time elements here, I want to move to the substantive issue, which is the interpretation of the policy. And I want to raise 3 points in that regard, which I believe make this case different from the typical policy interpretation case. The first, and most importantly, Your Honors, is that for over 100 years, the Court of Appeals has said that the rule against the use of extrinsic evidence in aid of construction of a policy does not apply.
Counsel,
when it is a stranger.
Let me interrupt. Why should the rule against this extrinsic evidence not apply based on the argument that the policy is totally unambiguous in the language it uses? It talks about work being performed over 2 stories high. This was not work being performed over 2 stories high. Why do we need extrinsic evidence to interpret that provision?
Well, first, I would say that there are 2 reasonable constructions of that language, Your Honor. That it's not just, it could be interpreted to refer to the particular work being done by a particular claimant at a particular time, but it also could refer, because of the breadth of the endorsement, it refers to the ongoing operations, which is the scope of the insured's contract work, which is in this case, more than just the 2 stories. It's more than 2 stories. But more importantly, the case I was going to cite to you from the Court of Appeals, and I apologize, it's not in our briefs, but it's controlling precedent, which I just found, and it's Lowell Manufacturing Company versus Safeguard Insurance, 88 NY 591 599, goes back to 1882. And it answers the question, Justice Kern, that you had mentioned. Why should we be able to use extrinsic evidence if the language itself is not ambiguous, or it doesn't apply on its face? You're saying.
Your time, you're way over your time, so I'm going to ask you to just please.
Can I wrap up with just the 2 other points? I'll deal with them.
No, I'm going to let you wrap up with a sentence. You'll have time on rebuttal, not 2 points.
I'll make it a long-winded sentence, Judge. The 2 other reasons why this case is different is because, 1, most of these other cases don't involve extrinsic evidence because it's standard insurance language and it doesn't even exist. Here is, we have a different situation.
That's more than 1 sentence. And
can I do and unlike every other case, Your Honors, we did not move for summary judgment, and therefore we did not have the burden of proof. We had to submit evidence to create an issue of fact. Thank you.
Further elucidate on rebuttal. Let's hear from
Mr.
Beer. Mr. Beer?
Thank you. May it please the court. Jeffrey Beer Jr. from Riker Danzig, Shear, Highland, and Peretti for the respondent. I won't belabor the procedural issue that's already been discussed, except to make a couple of brief points. Number 1, National Union has never asserted that it has better rights than the co-insured island structures. Mount Holly readily admits that island structures could challenge the improper disclaimer, and so can the co-insurer National Union. And contrary to counsel's statement, in many of these cases, the policies were not issued to the same policyholder. There was a matter of additional insured coverage, just like here. And I would point to 2 that I know offhand we cite in our brief: the indemnity insurance versus St. Paul case, which Justice Mazzarelli signed, and also the more recent Arch decision. In both of those cases, it was determined that priority of coverage, a point made in Mount Holly's brief, was not relevant because the named insured owed a contractual indemnity to the additional insured. As Justice Kern points out, that is exactly the situation here, where there's already a final judgment, not on appeal, that Mount Holly's insured, Iron, owes contractual indemnity to Mount Holly's additional insured island structures. Furthermore, National Union is not arguing that it would have standing to assert a declaratory judgment claim as to Iron only. All it has ever said is that it has standing to assert a declaratory judgment action as to the co-insured island structures, and it just so happens that that issue is dispositive of the coverage for the named insured Iron as well. Turning then to the merits of the applicability of the exclusion. Again, this has already been pointed out, extrinsic evidence is not relevant because the language is unambiguous. To conflate work and project in an exclusion which uses the terms separately is not a reasonable interpretation of that exclusion. And under Mount Holly's proffered interpretation, interior work in the basement of a building would qualify as exterior work over 2 stories, simply because the project might at some point in the future call for such work. That's contrary to the plain language of the endorsement. It's contrary to common speech, and it's also contrary to the precedent of this and other courts. And I would point to the West 56th Street decision of this court that we cite in our brief, where the court was presented with 2 similar exclusions with a notable difference. In one, the exclusion spoke in terms of designated operations that was certain work, like the exclusion here. In the other, it spoke of designated operations being any job involving certain work. And the First Department differentiated between the 2. Unfortunately for Mount Holly, its exclusion here is more like the former and does not apply where the injury-producing work is unrelated to the designated excluded operations. And because the exclusion is unambiguous, extrinsic evidence is not admissible. And just one further point on this is that the so-called evidence is not even helpful to Mount Holly's position because their underwriter has simply testified by certification that the exclusion should apply, quote, if the insured is performing work above 2 stories. But we know that's undisputed. That's not what was happening here. And so even if that evidence were to be considered, it's not helpful to Mount Holly's position, and the well-reasoned decision of the motion court should be affirmed.
Any questions, colleagues? All right, let's hear from Mr. Ambrosio again.
Yes, Your Honor. I just want to again reiterate this point about this Court of Appeals precedent regarding the use of extrinsic evidence, even if this court were to consider that the exclusion does not apply on its face and is not subject to different reasonable interpretations. The court there, in the specific context of this case, says the policies were not contracts between the parties to the action, and the rule referred to applies only in suits between the parties to the written instruments. The writing is not conclusive as between one of the contracting parties and a third person. And again, this goes back to the fundamental premise of contract interpretation, to figure out the intent of the parties. National Union is a stranger. They have no idea what was the intent of this policy. The policyholder is not challenging. Why would they get the benefit of the contra preferentum canon, which is one of last resort? We're just saying that the court should have at least considered the extrinsic evidence. It didn't consider it. It ignored it. Unlike other cases, this one has extrinsic evidence. Other cases don't because they're standard language. It probably doesn't even exist. And we did not move for summary judgment. Therefore, we did not have a burden other than to create an issue of fact, which we have sufficiently done. Now, with respect to the procedure, I just want to point out a couple of things that are just wrong. The cases that he talks about regarding, it comes up in the context of additional insured coverage. In those cases that he cited to, Your Honors, it was acknowledged by the insurer for the additional insured coverage that it existed. And then it was a priority of coverage determination. Here, we have never admitted or conceded or acknowledged that we owed coverage to Island. He just presupposes that, but that's the entire point. That has to be successfully challenged. Does he get to jump ahead and assert a contribution claim before the claimant, Island or Iron, have even challenged this disclaimer? And we submit that they're not permitted to. And again, he submits that the work being done was at the first story and therefore it doesn't apply on its face. The record shows, Your Honor, that individual claimant may have been working at the first floor, but the insured, we're insuring this iron company, not this individual claimant. They were doing work on the entire building at the time of the accident, not just down the road in the future. At that time, he happened to fall from the first floor, but they had other people working all over the building, and they're insuring a risk of the contract work, the scope of the work. And it's referenced in his contemporaneous notes. It's not just his after the fact affirmation. He's saying, look at my notes. My notes said I'm looking at this as a 2-story and under contractor. They do basically specialized work on 1-story building. That's all they have. So we submit that this should be considered. It should be considered because they're a stranger and they should not have the benefit of this canon of construction.
Thank you. Thank you. Thank you both. All right, the next case is Alberto versus Desano Demolition.
Christine Kasha for the plaintiff appellant respondents, Alberto.
Right, did the co-appellant appear? Do we have Carolyn Rankin? Okay, we're going to proceed without that. Go ahead.
Yes, Your Honor, I'm here.
Okay,
Hello?
I'm going to let you argue. You have 5 and 2. You weren't.
Thank you, Your Honor.
Okay. All right, let's start though with Ms. Kosia.
Okay, may it please the court. Good afternoon, judges. First, I'll start with, since there are multiple defendants in this case, I'm going to start with DeSano. Nick Soda, the man whose house was being built, and the man who owns Nico's Construction, who we say was the general contractor building the house, he testified that DeSano was the general contractor, not him. He testified that he paid DeSano for general contracting. If you go through all of the checks in the record, there were a total of $194,688 in checks. And if you look at all of the invoices sent to Nico's Construction from DeSano Demolition, that totals $148,000. That's 76% of the total paid by the Sodas and his companies went to DeSano Demolition. DeSano's name was on all of the permits.
Is the nature of your argument basically that there's more than the fact that DeSano pulled the permits here that would support a conclusion that DeSano was the GC?
Yes, that is correct. And at the very least, it raises a question of fact for the finder of fact to decide who was the actual GC, because there is more than just the permits. There's a lot more than just the permits in this case. Okay. I'm just shooting right to the points here, if it's okay with you.
You have a limited amount of time, so I'm going to encourage you.
Also regarding DeSano, they said they were off the work site at the time Mr. Alberto fell. He fell on July 17, 2015. There are invoices from DeSano after that date. There are invoices obviously before, but there's also one for December 2nd, 2015. And there was one just a couple months before for March 24th, 2015. So there, DeSano saying that they had been off the work site for months prior to the fall just isn't true. It's belied by the evidence in this record. Now, as to Nico's Construction in all respects was also a general contractor on this job site. They paid substantial sums of money to subcontractors, including Capital Building, who our client worked for. They paid numerous other subcontractors. They even hired rented out porta potties for the job site. That's something that's quintessential what a general contractor would do at a work site. A homeowner, even a homeowner with some knowledge, doesn't think, let me hire porta potties for the work site. And he went beyond what a normal homeowner does in controlling the work. Now, we also have the fact that Mr. Percivali, who was our client's boss, testified that there was digging going on around the scaffolding, and he had complained to Nick Soda about that digging prior to the accident. That puts Nick Soda on notice both as
This is Judge Mazzarelli. When does your client say that digging started?
It's my client's boss that says it, and he said that he complained about it 2 days prior to to Mr. Alberto's fall.
Thank you.
Okay. So that's something that puts him on notice. It puts Nico Soda on notice both as homeowner and as the principal and the owner of Nico's Construction.
I'm sorry, can you also address Manuela separately, since she was in a separate position? What, if any, involvement she had that would impose liability under 200 or common law negligence for her?
Only that, unfortunately, her deposition testimony was mistakenly not attached to the record, so I can't even speak to that without speculating, so I don't want to go beyond.
Are you pursuing your claim against her for 200 liability?
Against her doesn't particularly matter because we still have Nick Soda in it as her husband, and they're both.
I understand that, but we have to analyze each defendant separately. So I just want to understand if you're even pursuing a claim against her. It sounds like you're saying there's no evidence in the record to support the claim against her individually for 200 liability. Is that correct?
Yeah, that is correct. Yes.
Okay, thank you.
Okay. The other thing I just want to mention is that the August 13, 2019 status conference order directed that all summary judgment motions had to be made by November 4th. The plaintiffs, my clients, and DeSano moved on November 1st. However, Nico's Construction and the Sodas didn't cross move until January 9th and 10th, was 66 and 67 days after the status conference order directed that they have to move for summary judgment. While I understand the court can review the entire record to determine who's entitled to summary judgment, it doesn't mean that they get a right to argue their position for summary judgment, because the status conference order supersedes any right they might have. That ordered everyone to move by November 4th.
You need to bring your argument to a conclusion. Your time has passed.
Oh, okay. I am then done, and I'm happy to wait for rebuttal.
Okay. All right.
Thanks.
All right, Ms. Rankin.
Good afternoon, Your Honors. First, I want to apologize for missing the call. We had the wrong link. So I was in cyber, I don't know.
You're in cyber, I don't know. It's a new, as I say to people, it's our new reality. Go ahead. We're glad you could join us.
Thank you so much, Your Honor. So I represent the appellant defendant, Nico and Manuel Soda, who are the homeowners, distinct from Nico's construction company. And it is our position that the record is completely devoid of any evidence which would establish that Nico exercised the direction or control necessary to vitiate or void out the homeowner's exception to the labor law.
Counsel, this is Judge Kern. Isn't there some factual issue about whether or not his workers may have been responsible for the digging around the scaffolding that may have caused the scaffolding to collapse, which would therefore prevent those claims from being dismissed?
So in the first instance, I would defer that to the workers for Nico Construction, which is not my client. I represent the homeowner. But to answer your question, there is some very...
asking, counsel, I wasn't asking about Nico Construction. I was asking about Nico personally, because he was involved in the job site on a personal level, in addition to his involvement in Nico Construction. So that my question is directed towards him personally, not to Nico Construction.
My mistake, Your Honor. Nico Soda did not have any personal employees on the site. As an individual, he had no employees on the site. He only had contractors. And there's no evidence in the record to establish, nor has there been an allegation that Nico had any employees. And as far as who or what anyone was doing that digging, there is some suggestion that it could have been an electrical contractor. There is some suggestion that it might have been an employee of Nico Contracting, but there's no evidence definitively one way or the other. There's also no evidence that other than allegations, there's no proof that that was what caused the scaffold to give. At the end of the day, the plaintiff testifies about a plank being moved, and not even, it's only Percivali who testifies about it having shifted. And as a matter of fact, he had his fellows go right back up and continue to work that same day. I mean, if it had shifted because the foundation was loose, I would wonder why Percivali would have had the rest of the guys go back up and continue to work that day after the plaintiff's accident. However, if I may, to get back to the issue, I believe that is central with respect to Mr. Soda as a homeowner and Mrs. Soda as well as a homeowner, is the burden is to establish that they directed the method and the manner of the work. There's no question here that they told these contractors what they wanted done. And there's no question that they told these contractors where they wanted it done and what they wanted to look like. And when they didn't like what it looked like, they went and hired another contractor who told them, who would make it look the way they wanted it to look. But they never told them how to do that. They never said, don't you...
This is Judge Kern. Isn't there some argument based in this record that Nico was not really acting as just a homeowner on this site, that had a greater level of involvement in the construction site, above and beyond being a homeowner?
Absolutely. Actually, the record is completely ripe with those allegations, but there's not a single even allegation to support it. In other words, they say, hey, Nico, you're a general contractor. Hey, Nico, you supervise. But when you get back and say, okay, what do you mean by that general contractor? What do you mean by supervise? Nobody has any evidence of what they're out there are labels without any substance underneath them. I asked the court to go to Percivali. Percivali is the plaintiff's employer, and he's the guy who's on the scene every day. He specifically testified, Nico didn't talk to my men. Nobody talks to my men but me. No one can instruct my men but me. In the same token, he says, oh yeah, he was directing and supervising, but then he says, no. He wasn't allowed even to speak to my men. That's my law. Those are the words that Percivali uses. Plaintiff will tell you, he never even spoke to my client. He never had a conversation with him. And nobody ever says, although they throw labels at him. I'll give you that, Your Honor, absolutely. They never say what they mean by those labels. He never once said, as I say, use a scaffold, don't use a scaffold. Use a wrench, use a screwdriver. He never did anything. He didn't provide the scaffolding. He certainly didn't assemble it. Those were Capital's employees. He was just a homeowner trying to build his dream home. He had architectural plans. He went out, he hired a group of different contractors to do the work, and he gave them the plans, and he said, fellas, have at it. And when he didn't like the way he looked, he then went out and said, I'm sorry.
Ms. Rankin, I'm going to ask you to keep track of your time because you're way over.
Oh, I'm finished then, Your Honor. I thank you for your time.
Okay.
I
right,
hope
good.
I've made my. Thank you.
You'll have time for rebuttal. The DeSano demolition, Mr. Kolowitz.
Thank you, Your Honor. Andrew Kolowitz for Respondent DeSano Demolition and Anna Maria Appellate DeSano, and she's a principal of DeSano Demolition. I have to vehemently disagree with the characterization of the record by both of my esteemed colleagues. The testimony cannot have been more clear. Percivali testified, Ms. Appellate DeSano testified, Mr. Soda testified, and the testimony is all uniform that Mr. Soda, through his company, Nico Construction, managed the job, hired contractors. He paid from Nico Construction every single one of the contractors. He was on site every day. He paid for all the supplies, all the materials. When he didn't like the work of a contractor, he discharged that contractor. So he effectively was the general contractor on the site, and he doesn't dispute that. Mr. Percivali also testified, and he said the only one other contractor on site the day of the accident was Nick Soda and Nico Construction. My client, DeSano.
Counsel, your position, just so I'm understanding, your position is that there are factual issues as to Nick Soto's personal liability based on the role he took on at the job site.
Well, I think that that's correct, Your Honor, but my position is obviously also secondfold. We think that the court entirely got it right and that we are entitled to summary judgment on this record.
That's you, counsel, because there's a lot of evidence in the record, and this was sort of a confusing setup. It was not your normal construction job site setup for various reasons, but there's definitely evidence in the record, extensive evidence, about DeSano's role beyond just signing off on permits. So why doesn't that create a factual issue as to whether DeSano was a general contractor on the site?
Well, I'm glad you asked that, Justice Curran. I mean, that really is the question. And let me, if I can, just walk you quickly through the evidence. There is a contract or a series of contracts DeSano had with Nico Construction, and the contracts very clearly delineated the scope of their responsibility, which included utility cutoffs, demolition, erecting a fence, getting DOB permits for these activities, and ultimately the DOB sign-off after the demolition. After the demolition concluded, and again, this was in November actually of 2014, some 8 months prior to the accident, DeSano gets the sign-off in December and does not return to the premises. Now, I certainly understand just my colleague's argument that, well, DeSano was on the permits and DeSano...
It's not only that DeSano's on the permits, he's the only general contractor at the site. There is no other general contractor at the site. He's the only one, or it's the only one that has even the ability to get these permits. It applied as the general contractor. This testimony by other parties that they were considered to be the general contractor. So why isn't all of that in combination enough to raise a factual issue?
Your Honor, there is case law on this very point. And the testimony, I think, overwhelmingly was that Nick Soda effectively served as general contractor. We did not, when I say we, I'm talking about Desano. We were not on site managing the work. We did not erect the scaffold. We did not do the day-to-day activities. We did not hire and fire contractors. And there's case law directly on point in the First Department. It's the Kazov-Rosti case. And that's a case 96 AD 3rd 695, which talks about this exact situation where a party merely pulls permits, identifies themselves as a GC to the Department of Buildings, but doesn't actually do a GC-related role. There's also the case of Huerta, a second department case, but this is not the first time that this has come up where you have a party which lends its license to others to effectively pull permits. And I could tell you the testimony both from Nick Soda and my client was that my client, Desano, gave her license information to the architect, and the architect pulled the permits. And this was Nick Soda's testimony.
This is Judge Mazzarelli, but wasn't Mr. Desano listed as the general contractor on these applications?
On the DOB permit. Yes, that's correct, Judge Mazzarelli. That is accurate. And
doesn't that mean something? I mean, that he himself characterizes himself as a general contractor?
Well, it sure does mean something. And Your Honor, again, I would strenuously direct you to the case law, because all cases that talk about this very issue where you have a party who lends their license to others to pull the permits with the DOB.
You would allow that if there was something more than just the permits, that might create an issue of fact, not dispositive, but an issue of fact about whether your client was a GC.
I believe, Your Honor, that as a proposition would be true, but if you actually look at the evidence here, there were contracts surrounding what Desano would do, and they're a demolition company. After the demolition was complete, we were off the site. And again, I'll remind the court that Mr. Alberto...
Your adversary talked about later invoices that beyond the time that you said you were off the site. Can't we look at that to see if there's an issue of fact?
Well, look, you may send invoices because you didn't get paid, but it doesn't mean you're doing work. Sometimes I send clients invoices.
But we're talking about summary judgment. I agree. In the universe, what you're saying is true. It's true. There may be a perfect explanation for it, but I'm just trying to get beyond the argument that you're making, which is that the permits themselves are not enough. And I think you're right on the case law. And the question is, do we have enough to create an issue of fact? Not dispositive, but an issue of fact. Yeah, and that's the issue, right?
Right, you're right. I mean, that's a very accurate characterization, Justice Gish. And I would suggest when you look at everybody's testimony, in particular on the day of the accident, the testimony was, and this is Mr. Percibelli, who is the employer of Mr. Alberto, says, Nico's guys were working on the site. My guy was on a scaffold. Nico was responsible for the scaffolding, and the accident occurred. Nobody places my client Desano anywhere near this accident for months and months and months beforehand. And I would challenge my colleagues to point to a place in the record which establishes that we were on site even months prior to the accident. And that's really the point. We're a demolition company. And you're right, we did lend our license, but we were off this job site well in advance.
We understand your argument. Let's hear from Mr. Imbrogno.
Yes,
Imbrogno?
thank you, Your Honor. Again, the important thing about this case, and it's hard to do an oral argument, is that we would ask the court to go look at the evidence, because there are a lot of statements made, but the evidence doesn't support it. Nico's construction, the evidence shows, does interior work only, not exterior work. So they were not involved in the scaffolding or anything that happened on the scaffolding at all. Their job was interior work. Now, there is some testimony that somebody dug something somewhere near the scaffolding. There's no real showing that that's what caused the scaffolding to fail, but the evidence is that someone did that. There's no indication that that was Nico's construction people. In fact, there's some indication it involved electricians, which is not Nico Construction's work. So, and in fact, if you read the testimony, that's why I'm saying that unfortunately you have to really parse the testimony down. The head of Capitol said that he didn't see people a couple of days before the scaffold failed. He didn't see anybody doing any work around there. So there's no showing that Nico's Construction did that. Nico's Construction is a company. They did work, but they did work inside the building. Now, there is testimony that Mr. Soto did various things, but I'll say it, it's not really my job because he's not my client, but there's been an attempt to meld Nico's Construction and Mr. Soto together. Again, if you look at the evidence, Mr. Soto did what a homeowner is permitted to do. He set up the things that he wanted done, but he didn't do them.
So now let me ask you a question. All right, Mr. Soto was the principal of Nico Construction. No question about it, right? I
agree with that. Yes, Your Honor.
All right. So how do we know when he comes to the site whether he's wearing his "I'm my owner" site or I'm running the construction company hat? How do we know?
The testimony was that Nico's Construction only does interior work. There was nobody.
I know that that's what they claim, that's what they do. But how do we know that they weren't like exceeding what they normally do because it was, a special project to Mr. Soto? It's really hard to kind of sort this out. That's my only point, right?
To
really
I don't know
make
whether
that
it's hard.
kind of crisp line that you want us to draw, that all the evidence concerns the corporation is different and distinct from the evidence that concerns Mr. Soto himself.
Yeah, that's right. I'm relying on evidence, not on the fact that they could be doing something extraordinary. They could, for all I know, anyone could be doing something extraordinary. The proof doesn't support it. And I again will ask the court to look at the evidence, because you will see, again, with respect to Mr. Soto, who's not my client, but there are statements that he hired all the people, therefore he's in charge. No, the case law says he can hire everybody. What happened here is he hired a bunch of prime contractors. There was no real general contractor. There were prime contractors, and each of them had a particular role, and that's what they were required
so nobody
to do.
Was in charge. Nobody
there
was
not a requirement that anyone, the only people who were in charge was the prime contractor. So if you're doing the electrician work, you're in charge of that. If you're doing the interior work, as Nico Construction did, you're in charge of that. The only contractor that was in charge of scaffolding was Capitol. And they lucked out because it was their employee who was hurt, and therefore under the workers' comp law, they can't be sued. If that scaffolding had hit somebody else, then Capitol would have been a defendant in this case, and they would have been a proper defendant. In fact, I suggest they're the only proper defendant. They just happen to have an immunity under the workers' comp law. And that's, I think, is the reality here. And that's really the way this case should be viewed. And again, I will stop only to say, again, and I'm repeating myself, we would ask the court to look at the proof, not the statements.
You are repeating yourself. You said the same thing many times, so.
Yes, I will stop. Thank you.
All right, Ms. Corsica, go ahead. You have rebuttal. 2 minutes.
First, New York City Building Code, Chapter 3300. Section.
So let me just interrupt for 1 second. Sure. I do want to ask this question now that we're circling back about individual liability of Nick Soto. And what evidence is there other than the claim that it's just allegations of his personal involvement of the work that would impose liability on him and take him outside the homeowner's exemption?
Okay, first of all, he testified that he was doing the work as a homeowner. The New York City Building Code requires a construction superintendent for the construction of a new building. So according to the building code, there had to be one. He said he was working as the homeowner, so it's his own testimony that puts him there. As far as him directing the work, this is the issue. Mr. Soda speaks Greek and English. Mr. Percivali speaks Italian and English, and Mr. Alberto only speaks Spanish. So he had to, Mr. Soda had to speak to Mr. Percivali only, and Mr. Percivali spoke to his men because they didn't speak the same language as each other, and Mr. Soda could not have communicated with the workers, Percivali's workers, including Mr. Soda, because they don't speak the same language. And just because Mr. Soda told Mr. Percivali how to do the work and then he relayed that to his men does not mean that the direction wasn't coming from Mr. Soda, because it went through Mr. Percivali. Yes.
I just want to ask a question on the labor law 200 cases, which only are really asserted against the Sotos, right?
Yes.
Okay. Does it make a difference in this case in terms of either one of their liabilities, whether it's a means and methods case or it's a dangerous condition case?
Well, we have proof of both, but the dangerous conditions, the clear one that they had notice of, because it was the digging around the scaffold that caused the scaffold to subside, that caused the
so the dangerous condition, just you believe there's an issue of fact about which one it is, right?
Which one was it?
The characterization. It's not clear how to characterize this, or
I
is
would
it?
say much more it's the notice of the dangerous condition, much more than means and method.
So if it's a dangerous condition, then that applies to the Sotos, both of them, regardless of supervision, correct?
Yes, that is correct. Yes.
Okay, thanks.
Yes, thank you. One last thing I wanted to point out.
Hey, let me go back to this. Let me go to a follow-up question. That the dangerous condition that we're talking about is the digging around the site. It's not like a permanent condition. It's not like a broken step or a broken rail. It's the digging that's occurring at the site and the way the digging is occurring around the scaffold.
That is correct.
Is that a dangerous condition that would impose liability on a homeowner who's not otherwise involved in the work?
Because they had notice of it. The homeowner had noticed that there was digging.
Was there on a daily basis and knew what was going on at the work site?
Nick Soda had notice of it, her husband.
But we're talking about Manuela now. We're not talking about Nick Soda, because you just agreed that she should have liability under the dangerous condition theory. So I'm trying to understand where that liability comes from. If she was not at the work site, how would she have notice about how the digging is going on, since it's not a permanent condition like a broken step or,
right,
sidewalk? So what's your argument? Because you earlier said there wasn't liability, and now you're saying there is based on a dangerous condition. So I'm trying to come full circle with that.
Okay, there is, but it's not in the record. So I don't know how far I can go with that, but she testified she came to the site to look at the house on occasion, and she spoke to her husband about the ongoing work. But her definition wasn't in the record. Right. So, yeah.
Okay.
The other thing I wanted to mention was Desano did return to do more work on the job site in 2015 and 16, and that work involved cement work in the basement, on the balconies, in the street, and pavers that was done in the driveway. So there was
more than demolition.
Right. There was a lot of continuing work beyond demolition.
I think we understand your position. Let's hear finally from Ms. Rankin, rebuttal.
Thank you, Your Honor. So I want to address the court's questions about the Labor Law 200. First, I would direct the court to the Affrey decision, which is a Court of Appeals decision. And the interesting thing about Affrey is the facts are pretty much in alignment with the facts here. And the court, did the analysis under 240, 241, but they also turned to the 200 analysis. And there, again, they found that where the homeowner exercised no supervisory control over the activity, that the action, the cause of action under Labor Law 200 must be dismissed. As far as
did they characterize the nature of the claim as being a means and method as opposed to a dangerous condition in that case?
No, Your Honor, they do not. And I will address, if your court will allow me, the issue of the dangerous condition. If we want to go down that road, I don't think it applies. But let's say that, because the court knows better than me, if we want to go down that road, I have to challenge plaintiff's counsel or the plaintiff appellant's counsel in their recitation of the record. Persabali testified specifically about this issue, that Nico Soto was not on the site the day of the accident. And it was on the day of the accident that digging was occurring. And
Excuse
that he
me,
was
this is Judge
concerned.
Mazzarelli, but he also testified that they had been digging several days before.
Yes, but now we have to find, if it's a dangerous condition and it was digging several days before and there were no problems the day before, it was created on the day of. So, and Persabelli very clearly testifies that it was created on the day of. And on the day of, he went to his fellows and said, be very careful because they're digging around right here, right now. And he also testified that he did not call Nick Soda and tell him about it. So it's just like, a snow and ice case, Judge. If I have snow and ice, 2 or 3 days before and he clears it up, you can't hold him responsible for snow and ice 2 hours before when no one gives him any notice of it.
Well, he can if he's responsible for the creation of it.
Yeah, I'm sorry, Judge, I didn't hear you.
I said he can if he's responsible for the creation of it.
Yes, but not in this case. There's no, right now, the most.
You want to compare it to snow and ice? I don't think I think that's a slippery place to go.
It always is, yes, Your Honor.
All right, I'm going to ask you to wrap up. I've been generous with time, believe it or not.
My point is, there's no notice of a dangerous condition here. And if, in fact, the court were to take the suggestion of one, I would ask that you review very closely Mr. Persabali's testimony, where he establishes that anything that was caused by digging was caused by digging by what he thinks was the electricians, and it happened on the day of the accident. Soda wasn't there, and he didn't give Soda any notification. I do also want to say very, very quickly that, Soda's coming in and saying, this is what I want done, and is not the same as saying, this is how you have to do it. And there's no evidence, despite
we
all
understand
these
that you've made that argument already, and so we're going to move on. Thank you.
I won't
okay.
believe it.
Thank you. You're out of time. Way out of time. All right. People versus Anthony Richard.
Good afternoon, Your Honor. May it please the court. My name is Mark Zeno, and I represent appellant Anthony Richard. May I reserve 1 minute for rebuttal, please? I did originally request it. Thank you, Your Honor. The verdict convicting Mr. Richard of assault in the first degree was against the weight of the evidence because the people did not prove either that the injuries complainant sustained posed a substantial risk of death or serious and protracted disfigurement. There was no substantial risk of death because, as the people's own expert testified, the laceration to complainant's neck was only superficial. The only risks that the expert testified that wound posed was infection, just like any laceration.
Hello, Mr. Zeno. This is Judge Mazzarelli.
Hi, Judge Mazzarelli.
Hi. I thought there was testimony that the scar, there was a 3-inch scar that was readily visible on the victim's neck. That would, if that is true, that would constitute serious disfigurement.
Well,
according
I'll tell you exactly what the evidence was and the testimony was. There was evidence about the length of the wound on the day it occurred. There was no evidence about the wound's length on a year later at trial. The only evidence at trial was that there was a single scar above the collar, and in the words of the complainant, it was, quote, a little pinkish and not that noticeable. That was the complainant's own testimony, a little pinkish and not that noticeable. That is just not serious disfigurement. When he was asked—
Zeno, if I may, Mr. Zeno, this is Justice Kennedy, because the complainant also had testified that the wound still hurt. He also indicated that the wound was the first thing that person saw, and it made people wonder what type of person he was. And he really described, and these were his words, how hellish the year was since the attack, because of the scar. And certainly the jury could see the scar. I mean, they had an opportunity to see it because it was right underneath, I believe, the jawline, and it was visible above the shirt collar.
He also said that it was distressing and distracting, and that it interfered with his ability to find a job or to find anything related to what I do.
But, Your Honor, by the time of trial, it was not that noticeable and just a little pinkish.
Yes,
So,
but
yes.
Justice Kennedy said that the jury had the ability to evaluate that.
Well, I think that the Court of Appeals has said, I believe in McKinnon and the third department in Gordon, which I cited, said that there needs to be record evidence. You cannot rely on the jury. I mean, here we have record evidence, and for protracted disfigurement, there needs to be record evidence that it is a lasting injury, and the only evidence of a lasting injury is a year later. The complainant himself said, yes, I suffered because it was visible and it interfered with my ability to get a job, but by the time of trial, which was only a year later, he said it's not that noticeable and it's a little pinkish. He was asked to describe how long the wound was, and he was unable to describe it. He said it appeared to be raised and a little pinkish, and that's just not enough under the standard for serious and protracted.
Actually, I always thought McKinnon stood for the proposition that you didn't have to have photographs or contemporaneous other evidence, that the jury could make the evaluation at the trial by looking at the victim. I thought that's what McKinnon.
Well, it does stand for the proposition, Your Honor, that you don't need a photograph if there's other record evidence that a reviewing court can use to find serious and protracted disfigurement. You just cannot leave it to the jury to make that assessment. That's what appellate review is all about. There needs to be something record-based, and here, there was just the only thing in the record, again, a year later, was the testimony that it's not that noticeable, and that's just not. First-degree assault injuries is an extremely high bar. We're not talking about regular physical injury. We're talking about serious physical injury, and that's what's required. Not that noticeable doesn't satisfy that. If I could just briefly talk about the justification charge as well. The most, as I said, my client is guilty of is second-degree assault, but the court wrongly denied him a justification charge. There was clearly a reasonable view of the evidence that my client was threatened with a knife. We have a 911 call that was entered by the people in which my client told the 911 operator, still when he was out of breath from the incident, that he had been threatened with a knife. He told the EMS operator.
What effect, if any, on the defense does the fact that at trial your client testified that neither party had a knife, that neither he nor the victim had a knife?
And, well, the effect is that under People versus Steele, the Court of Appeals said you view the evidence in the light most favorable to the people. People versus Steele was a very similar issue to this one, where the client took the stand after an incident like this one, where there was a knife involved, and said, I wasn't there, I have an alibi, presented an alibi defense. And the Court of Appeals said, no, you look at the evidence in the light most favorable to the defense and say, is there a reasonable view of the evidence that there was deadly force? And here the people introduced that evidence, that reasonable view evidence. The people introduced the 911 call. They introduced the cops who testified that my client told them at the precinct that the complainant had threatened him with a knife. And that is a reasonable view of the use of deadly force.
All right, let's hear from your adversary, Ms. Schlossberg.
Good afternoon, Your Honor. May it please the court. Karen Schlossberg on behalf of the respondent. With respect to the justification, start there and then move on to the injury. I do think that it's quite significant that these statements that defendant is now relying on were actually introduced by the people as false exculpatory statements that defendant had contradicted in the grand jury. And again, at trial, he and his wife both testified that they were false. But even viewing them as true, even if you look at them as true, they still didn't establish cause to give the jury the justification charge. Because at most, even if you want to credit them, they established that the defendant said that Valencia had a knife. That was it. They didn't say why the defendant had to slit open Carlos Valencia's throat. In fact, as the officer testified, the defendant told him that he was able to disarm Valencia, lied and said that he was able to disarm Valencia by using his martial arts skills. And it was only after he disarmed him that he then used the knife in self-defense. So there's nothing indicated in these statements that indicates why he felt he needed to use the knife against Valencia, or certainly not to establish that he didn't have an opportunity to retreat safely. So even if defendant had presented that argument to the judge below, and even if he had preserved this argument that his own false exculpatory statements should be used to support the defense, they wouldn't have supported it anyway. Unless there are any other questions about the justification charge, I'll move on to the injury. And I just wanted to agree with the statements that were made by members of the court that the evidence of the injury here was certainly sufficient to warrant the jury's determination that it was seriously disfiguring. I mean, there's no question about it. Nobody who was in the courtroom who saw Carlos Valencia on the stand even thought to make this argument. Defense counsel didn't make it, which is why it's being brought now as a Wade claim instead of a sufficiency claim. He did not argue this to the jurors on summation, did not argue that the injury was insufficient. Nobody did. The judge said in sentencing, I realize this is not evidence, but just to give your honors an understanding of how significant this injury was, the judge said at sentencing that they were the kinds of injuries that would ruin a person's life. It was a huge gash. The jurors saw photographs of the injury at the time of the assault. It was a huge gash along his neck, right by his Adam's apple, all the way around his neck. This is not the sort of scar that you might get from surgery or from some other accident. This is an apparent scar that anybody could see anytime they saw this man that showed that someone had tried to cut open his throat and kill him. I mean, it's a very upsetting kind of an injury. And this suggestion that the victim was saying it wasn't that noticeable, clearly he meant it wasn't as noticeable because he also testified that it was pink, it was raised, it was on his neck. I don't think there's really any argument that it wasn't seriously disfiguring or any legitimate argument that it wasn't a serious disfigurement. Unless there are any questions about that or anything else, I'll rely on the argument set forth in my brief.
Any questions, colleagues? Okay, thank you. Mr. Zeno?
Yes, if there were testimony that it was, quote, a huge gash all the way around the complainant's neck, then I would be arguing that it was inadequate proof here. That may be the prosecutor's appellate argument, but there is no evidence in the record to support a, quote, huge gash all the way around the neck. It's just not there. The only thing that's there is that it was not that noticeable, a little bit pink, couldn't even articulate the length. And I would also just want to speak to just a moment as to the sentence claim. This was my client's first arrest, 53 years old. The Department of Probation recommended that my client get probation in this matter, which, as I'm sure you recognize, is an extraordinary thing for them to recommend. I don't think I've ever seen them recommend that in a violent crime. The court wasn't allowed to give a sentence of probation, but that should put in context what would have been an appropriate sentence here, and anything above the minimum was uncalled for here. Thank you.
Thank you. Thank you both. All right, the next case up is David Berg & Associates versus Wexler.
Thank you, Your Honor. Mike Fay for the appellants. Your Honor, we're here today seeking reversal of an order that was issued on June 5, 2020, that basically gutted our special proceeding. We had filed a special proceeding pursuant to Section 475 of the Judiciary Law to collect on a charging lien that Justice Marcy Friedman had granted us in 2017. On June 5, 2020, the IAS court withdrew our petition, our verified petition.
Now, let me interrupt you for a minute, because we're all familiar with the
Okay, sure.
So why wasn't it an appropriate act of discretion for the court to convert it to a plenary proceeding where you made the decision, or your client made the decision to not proceed on the charging lien, but instead decided to proceed on a quantum merit, which is a very different claim than a charging lien against the settlement?
The charging lien never went away, Your Honor. What happened was the charging lien was never vacated, was never appealed. What happened was that the settlement that was reached in 2016 and that Justice Friedman said, she originally said it's binding, but then she said, okay, well, I don't think all the terms are here. The parties negotiated for another 3 years, and in 2019, they reached the settlement. The lien was still in place. Prior counsel.
Can I ask a question, Mr. Fay? Because it wasn't like a traditional lien. The court actually kind of hedged when it said, yes, you have a charging lien, but I don't really know if it's going to hold up, and I don't know how much it's for. Didn't she say, in effect, that?
She absolutely did, Your Honor, because at the point, I mean, a lien has to attach to something, and the settlement was being attacked. But precedent from this court, and we cited in our reply brief, a charging lien doesn't have to determine the amount at the time. And think about it.
But she did more than that. But even so, let me ask you a question. All right, so it got converted to a plenary action, and I want you to assume for a minute that the court had the right to do that. Your lien didn't self-execute. You needed to otherwise have hearings, and there could be, in fact, questions, because you were proceeding in quantum merit, about what that amount would otherwise be. What's the practical difference to you in terms of it being, quote unquote, a summary proceeding and or being a plenary proceeding in which there is going to be a hearing ultimately about the issue of whether and what that lien consists of?
Your Honor, if we could have, first of all, if our petition was no longer withdrawn, all right, and which currently under this June 5th order it is, and if we could get someone to decide our motion to dismiss, I'm not sure what the practical difference would be. The biggest part of this, the June 5 order did 3 things. It withdrew our petition.
Your real objection, and maybe you can tell me if I'm saying it wrong, your real objection is that you never got a decision on your motion to dismiss the counterclaims on the medical malpractice, and that you want to have a decision on that motion. Is that correct?
Yes. We have two big issues. First is currently our verified petition is withdrawn. We'd like to have that fixed. Okay. Second, the very lien that we have sued upon under section 475 bars the malpractice claims that respondent has brought. Those claims were litigated in 2017. They've reasserted them here. This court and numerous courts in New York have said a charging lien bars malpractice claims. There's no reason why we shouldn't be able to get a decision under 3211 on that issue. The IAS court seems unwilling to do that.
But I think one of my colleagues asked about this before, but didn't you also seek recovery pursuant to quantum merit?
We were asked to. There was a charging lien. And then counsel for the respondents contacted us in 2019 and said, listen, we have a final settlement. Would you please modify the amount of your lien? And we did. We agreed. We reduced the lien by 1/3. That modification was then incorporated into an order that was issued on July 11, 2019. It was signed by Justice Friedman, and it was signed by prior counsel for the respondent. And based on that order, $860,000 was deposited with this court. The lien never went away. The only thing that happened was the amount was recalculated. That is what respondent is arguing here. They keep saying, well, Justice Friedman said the lien could have been vacated. It could have been, but it never was.
Mr. Fay, I'd like to go back because your petition did indicate that it was for an action in quantum merit for unpaid legal fees for payment. So since your petition, which was converted into a plenary action, is seeking quantum merit, what do you say about our case law that really a plenary action must be commenced when you're seeking judgment on a quantum merit claim?
I mean, whether it's a special proceeding or whether it's a plenary action on the quantum merit, we don't care. Certainly, the respondent has the right to challenge the amount. The issue is that the lien that gives us the right to file this case in the first place bars the counterclaims they brought. That should be decided. That should be resolved. And then we can have a hearing. We can have discovery. Is the bill that we have submitted? We have submitted our legal bills. Are these reasonable? I agree with you, Your Honor. That should happen. But what we have here is a court that is refusing to address what is a significant issue in the case, which is that there are these counterclaims that repeat something that happened 4 years ago, and there's no basis for it. This court's precedent says you can't have those counterclaims.
Right.
We would like that addressed.
Mr. Fay, let's hear from Mr. Levitt.
Thank you, Your Honors. Your Honors, I think you correctly pointed out that Judge Friedman did not find that the lien was valid, nor could she for a number of different reasons. And she recognized that. So at page 40 of the record, she said, I will not, however, at this time determine whether the charge in lien is enforceable or whether it should be vacated. She goes on and she says,
regardless of that, shouldn't the lower court then have otherwise addressed the motion to dismiss the counterclaims? Shouldn't that have been decided on its merits?
I think the court did, Your Honor, but I think the court did in a different way, if I may.
I didn't see it in the decision, but.
Well, the court said that the counterclaims would be withdrawn without prejudice. So that means that the motion, excuse me.
Let me stop you there. Is there any evidence that there was an agreement to withdraw those claims? That motion?
Yes, there was.
That motion? Really?
Well, I'm sorry. There was an agreement. There is evidence that Mr. Fay's firm agreed to convert the action to a plenary proceeding with full discovery. And
yeah, but that wouldn't make the motion to dismiss the counterclaims go away. That doesn't mean they withdrew that motion.
It doesn't, Your Honor, but I think that what Judge Perry was saying was, without discovery, Judge Perry found that there were a number of factual issues in dispute. In fact, he likened it to a tennis match at Wimbledon, where the ball was going back and forth and back and forth. As, by the way, did Justice Friedman, when she said that there were a lot of cross allegations that were going on. And so I think that what Judge Perry did, frankly, to go out of his way.
If that's the case, shouldn't there have been your motion to dismiss the counterclaims is denied? I mean, withdrawal sort of implies that the person who brought the motion made an affirmative either representation before the court or signed a stipulation or did something affirmatively that took the issue out of the court's hands and made it so that the court didn't have to determine the issue. And the court didn't determine the issue.
The court didn't, Your Honor. And if this court were to send it back to Judge Perry, I could understand on that issue. But I think the bigger issue is whether or not there is a lien that would block any malpractice. And that can't possibly be the case. Because if you look at what
But that was never decided below. Maybe you're right. But it was never decided below. Wasn't that the whole gist of the counterclaims need to be dismissed because of the existence of this claim? You say, no, they don't. There's no the lien that Judge Friedman decided didn't go that far. And then in the absence of withdrawal of those claims, the court had to say, you're right, or Mr. Fay was right. That wasn't done here, was it?
I can't, no, and I can't disagree with you, Your Honor, that it wasn't done. But what I'm saying is, but from our point of view, there's a lot more than that one issue. And that one issue becomes subsumed in the other issue. So if I may, Your Honor, the court, what Justice Friedman said was, upon resolution of this action, the parties will have an opportunity to move to enforce or to vacate the charging lien. So what she said even before the settlement, that was not a settlement, was determined by both her and this court to not be a settlement. She said, wait until everything is decided before there is a charging lien at all. That's number one. So she said, wait to determine that. And twice she said that we would have the right to vacate the lien if we wanted to. So there's already. I don't think we had to, Your Honor. And I'll tell you why. Because she said at the end of the proceeding, we would have the right to do that. And that's after there is discovery. If we had moved to vacate this, I would expect your court to say it's not ripe. Because there hasn't been
Judge Perry.
Excuse me?
You mean in front of Judge Perry? I don't understand.
If we had appealed, like Mr. Fay says, it wasn't ripe to appeal.
No, I'm not suggesting that. You know, you have a proceeding, they bring a proceeding to enforce a lien. Did you bring cross relief to vacate the charging lien?
Part of the relief that we're seeking, Your Honor, is we're taking the position that we didn't make a motion at this point in the case to vacate the lien, because we believe that Judge Friedman's decision says that we have the opportunity to do it, and it didn't say we have to do it the first step out of the box. It said you can do that, and as part of our malpractice case, all right, we're saying.
All right, I understand your position.
And then we're also the quantum merit.
Let's hear. Your time is up. Let's hear from Mr. Fay. You'll have rebuttal.
Thank you.
Go ahead, Mr. Fay.
Yes, Your Honor. Thank you. What Justice Friedman said about the lien, you could say about any order of a court. It could be vacated, right? We don't know what's going to happen in this case. The settlement could go away. The case could go to trial. It could be decided by Justice Friedman. You never know. They never moved to vacate it. They have never moved to vacate it. They've done nothing. And the reason they've done nothing is because they can't. Because they came to us and instead of
sure they can. Sure, they
well,
can.
I mean, they can.
They can, in the plenary action, bring a motion and assuming that you still have a lien in place, is to vacate it. Of course they can. That was what was contemplated. You know, well, so now we're getting sort of mired. We're getting mired in procedural stuff. And I guess, you know, I can appreciate Judge Perry's frustration in trying to kind of just straighten out the procedural stuff and getting you folks on board to a point where you can get a substantive determination of what ails each party and see who's right and who's wrong. You know, what's wrong with that?
Your Honor, if we could get a substantive determination of our motion to dismiss, that would be wonderful. I mean, we've been waiting.
And you may lose it, right?
Excuse me?
You could lose it. And then you would go on and figure this out. You could win it, you could lose it, right?
That's how 3211 motions work, Your Honor.
Okay, understood. Yeah.
Right. But I would say that they came. I mean, this is in our estimation outrageous. Instead of moving to vacate the lien, they came to us and asked us to reduce it, and we agreed to do that.
We understand. Yeah, we understand. All right, let's see your final 2 minutes, Mr. Levitt.
Yes. So, Your Honor, before Judge Perry at page 79 of the record, and this happened, I believe, 6 or 7 times, he said, the suggestion has been made to convert this into a plenary action, and we go to a preliminary conference, outline what discovery is needed, when that will be exchanged, so the case can move forward. What are your thoughts? All right. He said this 6 or 7 times. He asked about discovery. At no time did Mr. Fay or his associate say they didn't think that there should be full discovery. All right. I mentioned multiple times, since they consented to a plenary action, that we can have full discovery. And maybe what Justice Perry was thinking was that if there's full discovery, there's by definition, withdraw your motion now because you need facts to support it. Both sides need to have facts to support it. He should have said that. I understand what you're saying. But I think it's pretty clear that he felt that discovery needed to be necessary. It was necessary to determine the motion. Now, they come back and they argue, well, we were unfair because part of the record, which the first time we saw was in their reply brief, was not what they said, but what Judge Perry said. That just cannot be true. If you take a look at
Counsel, just say that we should construe his decision as denying the motion without denying the motion to dismiss and let the case go on for like a summary judgment. Is that what you're saying?
Well, I'm saying that I'm trying to ascertain as to why Judge Perry didn't specifically deny the motion. I believe that he felt that it was a given that if there's these number of factual disputes
Should we be guessing this, or should we just remand it for determination on the motion?
Well, I think Your Honor could either accept what he did with discretion, within his discretion under CPLR 103C, or you could read into what he is saying and just say that it had to have been denied because he was saying in multiple times, never argued to the opposite by Mr. Fay or his co-counsel, that full discovery shouldn't take place. And if full discovery takes place, by definition, there wouldn't be a motion to dismiss the counterclaims because the full discovery, the entire purpose of the discovery was on those counterclaims. And so there are 7 different times.
You'd be surprised the procedural context in which cases come up to us. In any event, Mr. Levitt, your time is up. We understand your arguments and we're going to go on to the next case. Thank you both.
Very much.
All right, Gennady Gallardo against Schweitzer.
Your Honor, Randy Mastro of Gibson Dunn on behalf of appellants, the Schweitzer firm and individual attorneys from that firm. Your Honor, this case concerns a major plaintiff's torts firm, the Gennady firm, suing its arch rival, the Schweitzer firm, and several of its lawyers, and another smaller firm in the space, the Garcia firm. Your Honor, we're not about client poaching. We're not here today about the merits, although our clients vehemently deny these vile accusations. What we're here about today is the question of whether the sole 2 remaining claims of the Gennady firm state a claim that should survive dismissal, when the rest of its case, 6 other claims, have already been dismissed, and whether its claims against individual lawyers should survive dismissal as well. Now, Your Honor, let's start with the defamation claim. Defamation, tortious interference, those are the sole remaining claims. Let's start with the defamation claim. The defamation claim here literally is that the Gennady firm had its own paralegal, Mr. Flores, pretend to be a potential client, surreptitiously tape record conversations he had with someone, Ms. Pena, who's described in the pleading as a runner, not an employee of either of the 2 law firms in question here, but a runner, tapes conversations with her, tapes conversations with attorneys at the Schweitzer firm. Those conversations do not contain any defamatory statements. And the only claim that has survived of defamation is an October 2018 conversation on the phone between Mr. Flores and Ms. Pena, in which Ms. Pena makes certain statements about the Gennady firm. Now, I respectfully submit that under this court's precedents, which have been written by or participated in the majority opinion by Justice Mazzarelli, every single one of those, Levitron, Nolan, and others, Your Honor, when you actually have an agent solicit the statement, that constitutes consent. and consent soliciting the statement constitutes a complete defense to an action for defamation. That's what Levitron stands for. Also, under those circumstances, there cannot possibly be any causally related harm that results from the statement. An individual speaking to your own paralegal. Now, Your Honor, for both of those reasons.
Isn't the bottom, this is Judge Mazzarelli, Mr. Mastro, isn't the bottom line here that the statements were made to the plaintiff's own employee, their own paralegal?
Completely, Your Honor. Their own agent.
Do you really have to go any further than that on this argument?
You don't, Your Honor, so I'll move on. You've got it completely right. The case dismissed on the defamation. I just meant on the defamation claim. So let me, unless anyone else.
I didn't even say that, Mr. Mastro.
I understand, Your Honor. That's why I'm going to go to the next claim, unless there are any other questions about the defamation claim. Now let's talk about tortious interference, because this is important. There's an important guiding principle when it comes to stating tortious interference against a law firm, because of course we're talking about an intentional tort that has to be pleaded with more detail than just making mere speculation or blunderbuss allegations. Two, we're talking about a relationship that is literally severable at will. The client can sever at any time for any reason.
Excuse me again, but you're also talking about violations of the judiciary law here.
Your Honor.
479 and 482.
Your Honor, let me come to that, because to state a claim for tortious interference, and I think this court's precedents are very clear, including the Burroughs versus Combs case, you have to allege but for causation tied to a particular party and a particular contract that has been tortiously interfered with. The but-for conduct, whether it's criminal or wrongful, and you're referring to the Judiciary Act, I'll come back to that, okay, has to constitute the interference with that individual that caused the breach or the termination of the contract. Now, Your Honor, here, we do not have that. We never get to the judicial code or judicial act statute because they do not allege any specific client breached any specific agreement based on any but-for causation conduct. The only client,
Mr. Mastro, they do talk about the use of runners to solicit clients.
Yes, but Your Honor, an allegation made through largely anonymous sources that do not allege the runner was actually employed by the Switzer firm or make any connection other than the bald allegation that
runners, as you know, you're familiar with what a runner is. Runners aren't employed by anybody, really, in that sense. They work almost on a case-by-case or a commission basis.
But here's the problem, Your Honor. Here's why they don't get out of the box. Because not only haven't they alleged that in the case of Mr. Rodriguez, the only Schweitzer client, the only former Gennarte client who switched directly to Schweitzer, they do not allege that there was a runner involved. They do not allege that any wrongful conduct occurred in that specific instance. And Your Honor, Mr. Rodriguez, we don't have to guess what Mr. Rodriguez reasons were. Mr. Rodriguez, in his affidavit, record 1489 to 91, tells us he switched because he was dissatisfied with the Gennarte firm. He tells us under oath that there was no compensation offered him. There was no defaming of the Gennarte firm. Nothing untoward happened. He switched because
Mr.
a friend of his
can I stop
using...
you for a minute?
Certainly.
That's one particular client. The allegations seem to concern other clients as well, although they're undisclosed, right? So is it your argument that because we don't know the identities of who these people may otherwise be, that the claim can otherwise establish the causation and we don't even get to the wrongful conduct?
Well, Your Honor, I'm going to leave aside that there was no wrongful conduct, but that's not for today.
I'm just saying for pleading purposes.
For purposes of a pleading, Your Honor, and tortious interference, I challenge my adversary to cite a single case in the history of this courthouse where you have affirmed a tortious interference claim without identifying the specific client, the specific contract, and the specific wrongful conduct that led to the tortious interference. There has never been any such case because the law in this state and in this department is you got to point out a specific contract, you got to point out a specific party, and you've got to point out specific wrongful conduct relating to the termination of that contract that constituted tortious interference. That's the problem, Your Honor. We don't live in a star chamber here, okay? We don't have anonymous sources saying, oh, this is how it happened. We don't have rank.
I think we understand your argument. Yeah.
Yes.
So
And if
your time is up. If you don't mind, let's hear from your co-appellant, Ms. Winston.
Certainly, Your Honor. I'm pleased
Thank
that
you.
you gave me rebuttal. Thank you.
Thank you, Your Honor. May it please the court. Georgia Winston from Walden Mockton Heron on behalf of the appellants, the Garcia Law Firm and Renee Garcia. Mr. Mastro addressed several arguments that apply to the Garcia defendants as well, but the fundamental issue here with respect to the Garcia defendants is that there are no facts alleged in the complaint or in the record indicating any kind of culpable conduct by the Garcia defendants at all, or connecting the Garcia defendants to the other defendants' alleged culpable conduct. And because of that, Janarte's claims against the Garcia defendants simply cannot be sustained. There are really just 4 main facts alleged against the Garcia defendants in the complaint, and they're all entirely innocuous. They allege that Garcia is a solo practitioner. His office is at the same address, his New York City office, is at the same address as the Schweitzer Law Firm. In 2018, 3 of Janarte's clients substituted the Garcia Law Firm as counsel of record, and Janarte had referred those 3 clients to a Dr. Colon. That's it. Those are the allegations in the complaint against the Garcia defendants, and there's nothing more in the fairly voluminous record. There's nothing, and I think this is undisputed, that establishes a direct claim either for tortious interference or for defamation. There's no allegation that Garcia personally uttered a defamatory statement. As Judge Mazzarelli noted, the defamation claim, that the single statement was made to Janarte's own paralegal in any event. There's no allegation that Garcia personally engaged in any wrongful conduct to acquire these clients. The sole allegations against the Garcia defendants involve lawful conduct. And what the Janarte plaintiffs are doing is trying to hang their hat on an allegation of conspiracy that is entirely conclusory and wholly supported by any factual predicates whatsoever. So the case law is clear that to establish conspiracy liability, you need to allege facts showing that the defendants knowingly agreed to participate in the scheme, or allege some independent culpable behavior, such as tortious behavior, criminal behavior, that establishes the defendant's participation in the scheme. And without either type of those allegations, the complaint must be dismissed. And the case law is very clear. I'll take Schwartz versus Society of New York Hospital, for example, 199 82nd 130. That's this court in 1993. And the court held that although tort liability may be imposed based on allegations connecting non-actors with tortious acts of their co-conspirators, you need more than a conclusory allegation. The mere allegation that a defendant acted in concert or was in a conspiracy without facts alleging independently culpable behavior is clearly insufficient for conspiracy liability. Fleischer, 104 83rd 536 says the same thing. There are several other cases. The case law is consistent here, and Janarte has not alleged a single fact showing that the Garcia defendants knowingly agreed to participate in the alleged scheme, and hasn't alleged a single fact showing that they engaged in any independent culpable behavior establishing their participation in the alleged scheme. And that applies both to the defamation claim and to the tortious interference claim. You can't wrap them up in this scheme where, again, there are allegations about what the runners did and them paying money and them offering to bring somebody to the Schweitzer law firm or to the Williams law firm. Not a single mention in the complaint or in the record of the Garcia law firm, not a single one. And so given that, what Janarte has tried to do is argue that they should be entitled to discovery, that despite the absence of any allegations, factual allegations sustaining their claims whatsoever, they should still get discovery in order to support their claims. But that's putting the cart before the horse. Because Janarte has not pleaded any facts that could provide a basis to hold the Garcia defendants liable, they can't possibly be entitled to discovery based on the just magical suspicions that they've created, and subject the Garcia defendants to expensive discovery on the basis of allegations of entirely lawful conduct. And doing so would open the floodgates to conspiracy claims all over the place. Anybody then could just say, and there was a conspiracy, and wrap anybody else into it, get discovery, try to pressure into settlement. It's a slippery slope, Your Honor, and it is completely unsupported by the law. And the law here is very clear. If there aren't any questions, I thank you, Your Honor.
Thank you. All right, let's hear from Mr. Robert.
Good afternoon, Your Honor. May it please the court. As the Supreme Court held in a 33-page, fully cited, point-by-point, meticulous decision on the appellant's motion to dismiss, and in an 11-page, very well-written decision, point-by-point, denying their motion to renew and re-argue, the Gennardi firm has clearly established its claims for tortious interference with a contract and defamation per se. The complaint and supplemental submissions before the Supreme Court and in the record
How have you established the defamation per se, sir?
Because the statements that were made, yes, they were made to an employee of the Gennarte firm, but the Nolan case, first of all, was a summary judgment case. And in the Nolan case, the representative was sent for the specific purpose of eliciting information from the defendant. Here, as the record shows, and as Judge DeAugust heard, the paralegal accompanied the client to make sure that the client was not accosted by a runner trying to solicit the case. Here we have the runner who approached Mr. Flores. Then as a result of that approaching Mr. Flores, the conversation happened. Then the conversation was by telephone, which was recorded.
Well, are you saying that Flores heard the conversation or he didn't hear the conversation?
No. Flores heard the conversation. The runner approached Mr. Flores and started to engage the conversation. That's the difference between this case and Nolan, in addition to Nolan being a summary judgment case. In Nolan—
Well, there's a lot of differences between this case and Nolan.
Yes, Your Honor.
So who initiated the phone call?
Well, the runner contacted the runner approached Mr. Flores in the lobby of the doctor's office.
I understand that, but who initiated the phone call?
The record shows that the runners then contacted Mr. Flores, and then Mr. Flores had several telephone conversations with the runners, which ultimately resulted in Mr. Flores going with the runners to the Schweitzer office, sitting in a conference room with Schweitzer lawyers. And one of the defendants, when he saw the runners, said, "Nice to see you again." And then the conversation that happened at the Schweitzer office was recorded, as well as the telephone conversations when the runner offered Mr. Flores first $2,000 if they signed with the lawyer.
We're not talking about the poaching. We're talking about the defamation, though.
I understand.
All right. So where in the course of these contacts did the defamatory statements occur?
There were two of them. As the record shows, it was in the doctor's office, and it was in the transcript of the telephone conversation that's in the record. That was a series of, I believe it was 3 or 4 calls over the period of a day. And the transcripts were before Judge DeAugust and are currently in the record before this court. So that it deals with the defamation component of it. As to the tortious interference component of this, first of all, as Judge DeAugust said during oral argument at page 41 of the record, the supplemental record, the court does not have to surrender common sense.
Well, you know what? Let me stop you there, okay? Because I'm going to ask you just a straightforward question. Obviously, we know what the judge said below. We're looking at what he said below, and we're trying to figure out what we're going to do about it, affirm it or not affirm it or modify it. So I respect that it was a considered decision. I don't take anything away from the judges below, but we have to look at it. All right, so now the question that I have for you is really the same that I had for your adversary. What are we to make of the fact that other than Mr. Flores on the tortious interference claims, there is nobody specifically identified?
Well,
No contract identified.
There were 4 clients who were at issue. Those 4 clients were then part of the record. Their names are before the record in this court, because in the original pleading under Rule 1.6, we did not feel we were able to divulge the clients' names because they were confidential without the court directing us to do so. Subsequent to the initial motion, we made an order to show cause before the judge. He then gave us the permission to give the names. We then gave the clients' names. And in Mr. Mastro's motion to renew and re-argue, he attempted to attach affidavits from the 4 clients at issue here, or the 3 additional clients that came of issue here. And that was all before the court below. And the court below still found that since this was a pre-answer motion to dismiss and that the Gennarte firm was entitled to every inference, that those affidavits, even if the court considered it, and it said it didn't, but even if it did, they would not have been enough to overcome the pleading and the supplemental submissions of the Gennarte firm. If the court actually looks at those affidavits actually ask more questions than they solve. They have phraseology such as, I'm not aware, I don't believe so. There's absolutely nothing dispositive in there. All we know is that we have 4 clients of the Gennarte firm. In a very short period of time, those clients went 1 directly to Schweitzer, 3 to the Garcia firm, and then shortly thereafter to the Schweitzer firm. And we have alleged in the complaint and in the supplemental submissions enough of information to support the sustaining of those 2 claims.
Okay.
Does the court have any other questions of me?
Any questions? All right, Mr. Mastro will give you some rebuttal. Go ahead.
Thank you very much, Your Honor. To answer Your Honor's question about the lack of any specificity, and to answer the question about who placed the calls. Okay, the record at page 315 to 27, 45 separate calls between Mr. Flores and Ms. Pena, many of them initiated by Mr. Flores, yet only 1 transcript was, supposed transcript, was submitted in connection with those phone calls. And the transcript submitted in connection with any meetings with lawyers was utterly unremarkable and professional. Now, coming to tortious interference, the reality is that they didn't identify any client other than Mr. Rodriguez, who has sworn, pages 1489 to 91 of this record, that nothing untoward happened, and he switched because he thought the other firm would do better by him, that Gennarte hadn't been doing well by him, and he was recommended by a client of the other firm. He identified the client. And finally, Your Honor.
Excuse me, Mr. Mastro. One thing your opposing counsel, one point he made that's very important is, for example, in the Nolan case, it was a motion for summary judgment. This is a motion to dismiss, and we're supposed to give certain deference to allegations of the plaintiff in a motion to dismiss, right?
Well, Your Honor, that's true, except he ignores that the Breton case, this department, you were on that panel, and the Dixon case were both motions to dismiss for exactly the reason Your Honor suggested. It's the law firm's agent, the law firm's employee.
But you still got the tortious interference claim to worry about.
Let me come to the tortious interference claim, Your Honor. There still has to be an allegation about a specific client, and that specific client had a specific contract that was tortiously interfered with for wrongful reasons. He has no such allegation in his complaint. And Your Honor, I have to say this, he acknowledged below his exact words. His exact words were that there is, quote, the credibility, end quote, of Mr. Rodriguez is not at issue in this case. This is after Mr. Rodriguez swore, I switched because I didn't like how you were representing me. A friend of mine who was with the other firm being represented told me to go there, and nothing untoward happened. No money, no nothing, nothing untoward. That's page 1652 of the record. End of story. When you have such conclusive evidence, and he admits that the credibility of the former client isn't at issue. That is exactly what this court has held in the Taylor versus Pulver case, is the kind of conclusive evidence that you're allowed to consider at this stage, and that means that claim should be dismissed. And the 3 clients he's referring to that he belatedly identifies later were not clients who switched from the Gennarte firm to the Switzer firm. There are 3 clients, all of whom have sworn the same thing, by the way. Nothing untoward happened. They left for perfectly appropriate reasons. That's record 1489 to 90 and 1711 to 1727. Those clients all switched to the Garcia firm. And months later, the Switzer firm, a larger firm that tries these cases, became trial co-counsel. That is not the kind of nexus or link. There's no allegation the Switzer firm did anything to induce those clients to do anything. And I have to just say this. They allege that the poaching occurred June to September 2018. Those are the dates they used in their complaint, record page 91, that it happened in the summer into the fall, and they brought their case in October 2018. Some of these people that they're talking about right here, 2 of those 3 people who switched to the Garcia firm, they didn't even switch to the Schweitzer firm, aren't even people who switched during that time period. That's what the record shows. Your Honor, the fact of the matter is the pleading has to say specific client, specific contract, and specific wrongful means used as to that client. There is no allegation about anyone in this case. And to the extent Rodriguez, who they belatedly identified, could be said to be someone they're alleging was poached, even though there's no allegation in their complaint that there was poaching runners involved in Mr. Rodriguez's case, you know for a fact, because Mr. Rodriguez has sworn to it, that that didn't happen and the reasons why he switched. And Mr. Robert has told us the credibility of Mr. Rodriguez isn't at issue. And now I say, Your Honor, respectfully, case dismissed, please. This is not what you do. Allow a law firm to be smeared this way. Allow a law firm to be smeared this way with vile, venomous accusations by an arch rival who sued several law firms, and then they have this kind of threadbare pleading. That threadbare pleading doesn't allow a claim to pursue to discovery.
Thank you. Let's hear from Ms. Winston. Final 2 minutes.
Thank you, Your Honor. I really just want to reiterate here that the case against the Garcia defendants is even more attenuated than what Mr. Mastro was just describing with respect to his clients. There's no wrongful conduct whatsoever alleged as against the Garcia defendants. There are almost no allegations alleged regarding the Garcia defendants at all. There is no reference in any of Gennarte's papers or affidavits, transcripts, phone records submitted in support of their opposition to the motion to dismiss that even mentions the Garcia defendants. On a motion to dismiss, the plaintiff has to show that they have alleged some sufficient facts to show that they can sustain a claim, and they've alleged nothing here. And to try to wrap the Garcia defendants in on the basis of a claimed conspiracy by just stating it was a conspiracy is clearly insufficient under the law, and there are simply no facts alleged to support it. And they, having not done anything in that regard, there's no basis for subjecting the Garcia defendants to a fishing expedition based on wholly deficient allegations. Thank you, Your Honor.
Thank you. Thank you all.
Thank you, Your Honors.
The next case is People versus Douglas.
Good afternoon, Your Honor. May it please the court. Katie White, legal intern with the Office of the Appellate Defender on behalf of Mr. Douglas. Your Honor, the 11-hour delay between the search of Mr. Douglas's car and when Officer Burgos finally wrote up any inventory.
I want to stop you for a moment, Ms. White. I want to focus in on something specific. To the extent that you make an argument with respect to the inventory search, that the pulling of the insulation exceeded the bounds, the people say you didn't preserve that argument. Did you?
That's correct, Your Honor. Counsel didn't preserve the challenge to Officer Bax exceeding the scope of the inventory search, but we ask that you read.
So you want us to look at that in the interest of justice?
I do. It goes to the core of what.
Okay, I understand. All right, let me just sort of finish some procedural stuff and then I'll let you go. All right, and then the second thing is that at some point in your reply brief, in a footnote, you claim that there was ineffective assistance of counsel. Correct?
Yes, Your Honor. That's in the alternative.
Is that the first time that you raised that argument in this appeal?
Yes, Your Honor.
And you've never made a motion, and
No,
it's
Your
not
Honor.
a direct argument on appeal?
No, it is not, Your Honor.
Okay, go ahead.
Okay, thank you. First, I want to address the significant delay between the search and the inventory search here. No court has ever sanctioned an 11-hour delay because, as the Court of Appeals in People v. Glock reasoned, a list made so long after the search is of little use, and the delay there was only 5 hours long.
Is there a per se rule about the length of time by which a search is no good?
No, Your Honor, there's no per se rule, but the case law and underlying justifications for the exception require a timely inventory. The inventory is the hallmark of the inventory search. So the question is really, what use does a set of vouchers that are made 11 hours after the actual search and made without the aid of a contemporaneous list really have? Because at that time, as Glock certainly pointed out, it's no longer to protect an arrestee's property or to ward off claims of theft. And critically, in this court, in People v. Lee, this court sanctioned a delayed search only because the officers had made a contemporaneous list of the items removed. That list then guided the officer and Lee in making the vouchers, about 5 hours later. But here, Officer Burgos and Box didn't make any list at or near the time of the search that could help them 11 hours later, which is double the length of Glock and Lee. Now, writing down a list at the time of the search, it's not an onerous requirement, but the fact that the officers didn't take the few minutes to note the items removed, it doesn't show that it was difficult to do, but that the search doesn't meet the minimal constitutional requirements that makes this search any different from a search that requires a warrant. But holding differently would have this court just ignore the underlying justifications for inventory searches, again, that are separate from searches that require a warrant, basically eviscerate Glock and Lee and hold that any inventory search is valid no matter when a list is finally made. If there's no questions on that, I will turn to the inventory search itself, Your Honor. Officer Box did not provide any record testimony as to how pulling down the car trunk insulation, sticking his hand inside, and pulling out a bag containing a gun complied with inventory search procedure, as this court and the Court of Appeals require that he do. He merely said, quote, "There was a gap in the insulation, and then I noticed that. I pulled the insulation down." That was it.
Why isn't that okay under the authority of People versus Padilla? Where the court said panels askew, door panels askew justified a look, a pulling out of those panels to see what was behind.
Yes, Your Honor. So in Padilla, first I'll say the Padilla holding wasn't that it was actually reasonable for the police to search the pockets of the front seat of the car, which is a place that people routinely store things. The holding was that the officer was justified in seizing the drugs that he located after removing the speakers in the trunk.
Well, that was part of it, but the court actually did specifically address the askew door panels.
Yes, they did.
And it said that what the court did, what the officers did when confronted with that was okay. That was okay.
Yes. So the court there says that it was reasonable for them to do so because the question concerning the askew door panels was that the officer said that he was looking for contraband. And the idea here is that the contraband is not the sufficient grounds to validate a search. You see, the officer still needs to know what the protocol requires of them and testify to how they followed it. We don't have that here. Officer Box doesn't testify how pulling down insulation aligns with the protocol. So that's really the central issue, not about contraband or irrelevant, intent. And in the Court of Appeals in People v. Gomez, they say that, quote, even assuming that it was reasonable for the officers to search the immediate area of the passenger compartment for contraband or to ensure the safety of the officer or what have you, the people did not establish the circumstances under which opening and searching a closed trunk or a door panel would be justified under the protocol. So that's really the key issue. He needed to provide the grounds for why pulling down.
Well, was the fact that the officer testified that there was a gap between the insulation and the door, was that an indication that something may be hidden there as opposed to just physically pulling apart a car without any reason whatsoever?
Right, Your Honor. So the gap we're submitting, the gap is just a fact. It's not a justification. We can sit here all day and guess where, valuables may be stored in a car, for instance. But what the prosecutor needs to meet their burden is for the searching officer who found the central piece of evidence in this case to put on the record his justifications for doing that, for why that gap would link to an inventory, would link to one of the three permissible justifications for an inventory search. Otherwise, he's just investigating the gap, and that's no different from a search without a warrant. He could have said car insulation is a place where valuables or where people routinely keep their valuables. That was okay in this court in People v. Ramirez, where they say a spare tire compartment is a place where people routinely keep their valuables, because that the spare tire compartment, just like the insulation, is not a place that's listed on the police protocol, which controls.
That's not an exclusive protocol, though.
No,
it's not, right?
No, it's not exclusive protocol, but if you're going to take an extra procedural action, then you need to justify it. The protocol itself, kind of think about it like it acts like a substitution for the warrant in cabining the officer's discretion. And we know that the officer's discretion is properly cabined through their record testimony of how their actions complied with the protocol. But Officer Bash,
so in other words, you would have no issue with this search if the officer was asked and might have said, yes, I saw the gap, and that's kind of unusual in a car. You don't usually see insulation with a gap there, and it indicated to me that there might be contraband in there. That would be okay?
Well, if that were the case, we would be having a different conversation about whether or not they also put on the record their grounds as to why it was justified. Contraband, again, it's not sufficient grounds, though in this case, the searching officer did say that he believed inventory searches were for the purpose of finding other contraband. The searching officer.
Yeah, I use contraband too widely. I was thinking of the third justification,
right,
which is in terms of finding a weapon or something of that nature. So forgive me on my question. All right, we're going to hear from your adversary now, and we'll get back to you on rebuttal.
Thank you.
Good afternoon, Your Honor. Good afternoon, Your Honor. Thank you, and may it please the court, Stephen Kress on behalf of the people. So I just want to quote from Padilla in that case, where they said it was reasonable for the officer to check in the seat panels that were askew as part of his inventory. And I think, as Justice Gish was pointing out, that's very similar to what happened here with Officer Bash pulling down the insulation in the back of the car. The patrol guide specifically
had there not been a gap, you would agree that he had no right to do that.
I don't think he would have even known, or it wouldn't have been clear.
We don't know. Nobody asked him why he did it, really.
Right, but there wouldn't necessarily have been a reason to believe that something of value could have been stored in that gap. It might not, or in the area between the back seat and the trunk. It might not have even known that such an area existed if not for the gap. But I will say that the patrol guide, which was admitted into evidence in this case at the suppression hearing, states that
the patrol guide was that evidence filed with this court?
I don't believe I submitted a copy of the patrol guide.
It's been amended since 2015.
I could, if you'd like, Your Honor, I could certainly send a copy of the patrol guide that was admitted into evidence in this case. I can send a copy to the court.
Yes, please.
Okay. Well, the patrol guide specifically stated that the officers are to search any area where valuables might be contained, And the officers in this case testified they followed the patrol guide. They don't need to specifically say, and this court has never required them to specifically say, why they searched every single area of the car. And in Padilla, the court did note that with respect to a different search, a search of the another part of the car, that the officer testified that it's policy to remove owner installed pieces of equipment in the car. But never once the
right, but the police officer in Padilla provided a whole lot of information of what his thought process was as he was going through the inventory search, what he was trying to do when he went into the different areas of the car and the different things he did, like removing the audio system.
Well, with respect to the audio system, yes, Your Honor, he did say why he removed that, but I don't believe any explanation was given for why, or other than his belief that with respect to the seat panels, that sometimes contraband is contained behind that. And I think he was referring to drugs, and he didn't give any specific, he didn't say, you could also store valuables behind, behind these seat panels here. So I don't think there was any need for the officer in this case to say, point out the obvious, that yes, if there's an area where something could be stored, whether it's a valuable or whether it's a weapon, that the patrol guide authorizes me to search that. The patrol guide says so itself. I will also speak just to defense counsel's point about creation of a contemporaneous list. The officers testified that they put every single item as they were searching the car into one bag. So everything is there. It's all in one place. It really doesn't matter whether he's creating a list at the exact same time. There's not a question of what was removed for the car, what wasn't removed for the car. Everything that was taken from the car was put in one spot in a bag. So they could then go into the precinct, remove the items from that bag, and create a list. And there's not going to be any doubt of what came from, or the items that came from the car. In fact, every single item that was removed from the car was put on a voucher list. And I want to emphasize the reason why the court has required making a meaningful inventory list, and one that has to be done, relatively close in time to the search. I think it's because, if you remove items from a car and then search, don't create an inventory for 5 days, it indicates that really, your purpose in searching the car really wasn't to perform an inventory. And that's not what happened here. It's not like the officers were twiddling their thumbs. I mean, they found a gun in the car. That's a really serious thing. And they had to call the evidence collection team to come and do the processing. All throughout the night, Officer Burgos is creating different vouchers for different pieces of evidence. He's completing his arrest paperwork, completing arrest processing. And eventually he, finishes creating an inventory of the list. So this is just it's not in any way an indication that this is a pretextual search. And I do want to speak briefly to the sentence in this case, just to say that this court's decision in People v. Dilworth, which completely blows up the defendant's claim that the court could not impose an appeal waiver, if in fact that's what happened in this case. We're not actually sure about that. I believe that leave was just denied in that case. So People v. Dilworth certainly stands as the precedent in this department. And if the court has no other questions, I'll just ask that the judgment be affirmed.
But let's hear from your adversary for rebuttal.
Your Honor, 2 quick points. First, my adversary says that police officers are not required to point out the obvious when they're searching to decide whether or not they can search a certain area in a car. That's not true. The protocol are the rules to the game, and they need to say how they are playing that. They need to say, it's a very low bar, but they need to say, I saw the gap, and because I believe that there were valuables inside, that's why I searched it. If they're not doing that, then they're not performing an inventory search. They're just using their personal discretion and they're searching. And we ask that the police do this. We require that the police do this because the Court of Appeals in Gomez says that the point of inventory searches is that they're carried out consistently and reasonably. Okay, familiarity and adherence to protocol ensures that consistency. Now, to the contemporaneous list that needs to be made, it doesn't matter that he inventoried the entire car and threw everything into a bag. What matters is that the bag just sat somewhere unattended where the items were unvouchered, and then when they were vouchered in the future, 11 hours later, it's just the name of the item on a voucher, and that's it. They're useless for what they're for the purpose of, say somebody comes in and they're like, and they say, I had my grandmother's brooch was in the car and it was and it's no longer in this bag. We don't know that a list at the time of the search, if there's no list at the time of the search that says like there's the brooch, there's no way to know that. So it's useless for the purposes of what an inventory list is. The justifications that he gives are plainly not satisfactory either to cause such a long delay. That he had to wait for a single piece of evidence to start the voucher process is just implausible. Even if the clock is started when he first vouchers the gun, there's still a 6-hour delay, which is much longer than what the Court of Appeals permitted in Galak. And critically, he still, at that point, 11 hours later, has no aid of a contemporaneous list that this court requires in Lee to sustain an inventory search rather than just a regular search.
Right.
So with that,
thank you. Thank you both. Right, the next case, American States versus Graphic Arts.
Yes, good afternoon, Your Honor. Howard Edinburgh, Hirschfeld and Rubin, attorneys for defendant appellant Nova Casualty. Your Honor, as a matter of law, Nova should have been held to have no duty to defend Ready Mix, which was a stranger to Nova's auto policy with its named insured Commercial Concrete. Under the Nova policy, while Commercial Concrete was insured for accidents resulting from the ownership, maintenance, or use of its vehicles, a stranger to that policy would only be covered if it was, quote, using the vehicle with the permission of the insured. Nova has shown in this record.
Counsel, Judge Kern, obviously for a duty to defend, you just look at the complaint, and if the complaint alleges anything that supports that duty to defend, it comes into play whether or not. So if you could focus on why you think the allegations in the complaint are not sufficient to show an allegation of permissive use.
Yes, Judge Kern. The complaint, the amended complaint of the county, and really all of its allegations are kind of summarized even in its first opening paragraph. It does not, it alleges that Ready Mix and Commercial Concrete were independently negligent with respect to washing out either their own vehicles on their own property or failing to contain the concrete slurry from migrating off that property. There's no allegation in the complaint, and it's not even a reasonable inference from the pleadings that Commercial Concrete was, or that Ready Mix rather, was using Commercial Concrete's vehicles to conduct the washout with the permission of Commercial Concrete, or that Ready Mix was supervising or controlling the washout of Commercial Concrete's vehicles. Those allegations are not made in the pleading. The pleading deals with each party's separate and distinct negligence at their respective facilities and trucks. That's certainly, I think, the only plausible way to interpret and reasonable way to interpret the amended complaint. But even if
that, by looking at the complaint, the way that the amended complaint is drafted, where the two companies sort of are intermixed with each other, how can we tell what they mean exactly in terms of one versus the other? Isn't there enough there to say, hey, this could be alleging a permissive use by Ready Mix of Commercial Concrete trucks?
I don't think so, Your Honor, because they're alleged to be on adjoining properties, There's no allegation that they were co-owners of trucks, or that they were co-owners of the premises, or they engaged together in the washouts of their respective vehicles. But I think, and there's, even if there was an allegation of use, there's no allegation of permission. Under the law, for permission, you either need a written contract, and there's no allegation of that, or you need an allegation that commercial concrete was supervising the work that Ready Mix was doing, and there's none of that either. Even if, as the county's attorney alleged in the motion to amend, that Ready Mix allowed commercial concrete to do the washout. Allowing somebody to do something is not the equivalent of permissive use under New York law. I would say this, that if you focus on the word use versus maintenance, and that's really one of the core issues in this entire case, entire appeal, and then you focus on the activity which the court below had to define whether it was use or maintenance, the washing out of the drums after work, after they discharged their concrete, to prevent the residue of the concrete from hardening and affecting the operation, then you apply the common law as to what use is in New York and elsewhere and what maintenance is. And under all the definitions of maintenance in New York cases and nationally, maintenance has traditionally and classically and historically been defined as an activity you do to keep a vehicle in good repair, in good condition, to prevent its deterioration, to allow it to perform its overall function and its efficient operation. That is precisely what the washout was. It was a maintenance activity we submit as a matter of law. It's not ambiguous. The terms use and maintenance are obviously not defined in the policy. They are terms that have arisen over, generations of common law decisions. And the court below said that the distinction between use and maintenance that the court below used was that, well, it was done daily and it was essential. And we submit, Your Honor, that the courts don't make a distinction between maintenance, which is done daily, or less frequently. Either way, it's still maintenance.
Counsel, this is Justice Kennedy. Now, wasn't the washing of the vehicles necessary to even operate the vehicles? I mean, if the concrete hardens, how can the vehicles be used?
Well, that's just it, Your Honor. We are not saying the washing out was unnecessary or not essential. What we're saying is that maintenance doesn't become any less maintenance because it's essential. It's difficult to get a non-essential maintenance if you don't do it. If you don't do the oil on a vehicle, yeah, maybe you can get away with it for a few days, but eventually if you ignore it, your engine will freeze and you won't have a car. Either it's maintenance or it's not. If it's non-essential maintenance, that doesn't make any sense. All maintenance is essential, because if you don't do it, eventually you're going to lose the ability to have a functioning vehicle. If you don't wash out the concrete on one day, it could still mix the concrete, but over time it will make it unable to do it. But that doesn't make it a use versus a maintenance. The use category has historically been the gap closer between operation and maintenance. The use category, as it's evolved historically, has been incidental to the operation of the driving of the vehicle, or where there's an emergency repair is needed on the highway, like changing a tire or fixing some component that you had to do right away to continue in your operation of the vehicle. That's not this. It's like saying, is there danger?
Do we understand Mr. Edinburgh's argument? Because time is way over. Sorry. All right, let's hear from Mr. Potishner. You have to unmute yourself, sir.
Yes, may it please the court. My name is Marshall Potashner. I'm arguing for the respondents. First, I'd like to note that Nova, on its reply, appears to abandon the argument that Commercial Concrete did not own the vehicles. In fact, it's undisputed that all the vehicles at issue were owned by Commercial Concrete. They even put in a lot of evidence that all the vehicles were Commercial Concrete. None of them were ready-mix vehicles.
This is Judge Kern. Should we be considering evidence in this case, since this is a duty to defend? Shouldn't we just be looking at whether the allegations in the complaint, one way or another, are sufficient?
Well, yes, interesting. So for the duty to defend, we look at the allegations of the complaint. Now you can look.
Looking at the extra evidence.
You can look at the extra evidence to trigger a duty to defend or support a duty to defend. You can't look at it to negate a duty to defend. So to address Your Honor's earlier question about the allegations, you take a look at the second, the amended complaint, and that's on page 1565 of the record. They specifically state that the blockage of the Rushmore Street drain was caused by the conduct and operations of Commercial Concrete and New York Ready Mix, specifically washing out concrete mixing trucks on or near their facilities. And we know from the extrinsic evidence that all those trucks were Commercial Concrete trucks. In addition,
there's no question based on the complaint and the extrinsic evidence that there's enough to create a duty to defend, because there had to be permissive use of Commercial Concrete trucks by Ready Mix.
Yes. And here the duty to defend exists if either there's a reasonable possibility that the underlying action alleges that Ready Mix was using the vehicles, and or that Ready Mix is being sued for the conduct of Commercial Concrete. I would submit that both possibilities are alleged in the underlying action. Indeed, in their motion to amend, as the county argued as the basis for their claims, that New York Ready Mix either was involved in conducting the concrete truck washouts, or
where is it in the record, or I don't know if it's being refuted by opposing counsel, where is the evidence in the record? Do you know what page it is that establishes that all the trucks were owned by Commercial Concrete rather than Ready Mix?
Yeah, okay, so we, in our brief, they made a big issue about that in their initial brief. And in our brief, we addressed that in detail, pointing out time after time after time again that the evidence showing that they were Commercial Concrete, and I laid that out on pages 24 through.
That's your brief, which is just legal argument. Is there evidence in the record that supports what you're saying in the brief?
Yes. In the initial complaint on the record at page 1174, they alleged it was Commercial Concrete trucks. In addition,
you made a I'm sorry, maybe I'm not being clear. You made a representation that the evidence is now established beyond the allegations of the complaint that all the trucks were owned by Commercial Concrete. I'm just asking if there's somewhere in the record that supports what you are saying. That the
yes. At 1821, Mr. Notor, I cannot pronounce his name, Notorantonio. He's the president of Commercial Concrete and the vice president of Ready Mix. He submitted an affidavit that's in the record at 1821 saying that Ready Mix did not own any concrete trucks. In addition, there was video evidence that was submitted in the underlying action supported by affidavits showing that they were all Commercial Concrete trucks, and that affidavit's in the record 1827 to 1833. The NOVA policy lists the trucks on the policy as the covered vehicles. In opposition to a TRO, Commercial Concrete said, if you don't allow us to do this on Ready Mix's property, we can't operate. That's also at 1823 of the record. And even in NOVA's disclaimer letter, they admit it was Commercial Concrete trucks. That's why in their reply, they'd never ever gone back and disputed the ownership of the trucks. And here, I'd like to move on to this use argument. And the issue is they're creating a false narrative. It's not mutually exclusive. When the plain language of the policy permits more than one reasonable meaning, the court should adopt the meaning that upholds coverage. So here, the issue is not use or maintenance. It's whether the conduct alleged in the underlying action could be reasonably construed as using the vehicle. And here, similar to filling a car with gas, a reasonable person would not see that simply that filling a car with gas as you're driving down the highway, stopping at a gas station, that's not maintaining the vehicle. That's part of the use of the vehicle. The Second Department said as much in the Gerling case. It's necessary for the day-to-day use of the vehicle. Similarly here, the cleaning out of the cement trucks at the end of the day is part of the day-to-day use of the vehicles. It's not mere maintenance. Indeed, and even in the underlying action, in opposition to the TRO, Commercial Concrete argued that it is not able to wash, that if it is not able to wash out its trucks, they will be unable to operate. And indeed, if you look at the cases even that they submit, it supports our position. But when you do look at the cases, you need to understand that the term maintenance or use used in a exclusion is interpreted narrowly or construed narrowly under the law. And where here we're talking about in a grant of coverage, which should be construed expansively in the favor of coverage.
I'm going to ask you to wrap up your argument.
Oh, okay, Your Honor, I didn't get to the permissive use issue, but I'll move on to the vicarious.
You're out of time, so I'm going to ask you to wrap it up.
Okay.
We do have your briefs. I mean, it's not like if you don't mention every single argument that we're not aware and we're not going to address it. We will. I'm
not going to address that. I'm going to just wrap up my argument. I just wanted to give 2 or 3 sentences on the vicarious liability issue. They argue in their briefs that Ready Mix did not use the vehicle, did not own the vehicles, did not wash out the vehicles. If so, there can be no other base for Ready Mix to be sued but for vicarious liability. So they sort of have it both ways. They say, well, you didn't use the vehicles, you had nothing to do with them. Well, then why are we being sued for the wash out of the vehicles? It must be for vicarious liability. Either or creates the coverage. Thank you, Your Honor.
Thank you. All right, Mr. Edinburgh, 2 minutes.
Yes, thank you, Your Honor. Just Mr. Notaritano and Mr. Cerrone, in those same affidavits, stated under oath in the underlying action that Ready Mix doesn't own mixer trucks. They don't employ the drivers for the mixer trucks. They don't do the washouts of the mixer trucks, and they had nothing to do with the washouts of the mixer trucks. Those affidavits were submitted by respondents. Those affidavits were submitted by the court below. It's the type of the judicial admissions that they were never used by Ready Mix. The Court of Appeals in Northville versus National Union said these kinds of judicial admissions can be considered in motions such as the one that was made below. It would be unfair to compel NOVA to defend Ready Mix on the basis of permissive use of trucks, which Ready Mix owners swore they never used. As far as vicarious liability is concerned, to have such an allegation, you'd have to show there was an agreement. There's no agreement alleged. You have to show that doing this activity was inherently dangerous, even if due care was used. There's nothing of that. And finally, you would have to show that Ready Mix was somehow controlling or supervising the activity. And that's not alleged either anywhere. So there's no way that the amended complaint could be interpreted to allege any acts of vicarious liability. Thank you.
Okay. Thank you. Thank you both. Right, the next case, Leopold v. Bakharov.
Yeah, yes, good afternoon, Your Honor. May it please the court. Thomas B. Juneau Jr. from Armstrong Teasdale for the appellants David and Michael Bakharov. Petitioner commenced this special proceeding under CPLR 7510 to confirm the arbitration award, but the judgment radically modifies the arbitration award by adjudging facts that are contrary to the findings of the arbitrator and awarding an amount that far exceeds that which the arbitrator directed the respondents to remit to petitioner. For example, the judgment states no interest is due on the $400,000 note after the March 2013 satisfaction, but the arbitrator specifically found the note was not satisfied. Moreover, petitioner admits in his brief repeatedly that the arbitrator made no determination with respect to the payment of the note. Also, the judgment states respondents' equity contributions were fully repaid on May 19, 2014. But again, the arbitrator found respondents are entitled to reimbursement of the remaining principal balance of their equity contributions to be repaid pursuant to the governing operating agreement. The judgment would render that finding by the arbitrator nonsensical, because the arbitrator found that there is a remaining principal balance to be repaid. It could not have been fully repaid on May 19, 2014. Moreover, again, the petitioner in its brief.
The arbitrator didn't determine the extent to which the $400,000 note was paid. Said something is due, less amounts paid. Is that in the record any place, what amounts were paid, so that somebody could simply calculate what's due?
No, in fact.
So does this have to go back to the arbitrator, or does it go back to the court for calculation?
Well, one of the arguments that the petitioner makes in, or respondent makes in his brief is that these are ministerial calculations, but the fact of the matter is they're not ministerial calculations, because all the factors in the equation are variables. In fact, on 20
are some of them sort of ministerial? Say, for instance, part of it, what I understand, your dispute is the priority of payments. How is the money that was given to be accounted for against what debt is it paid first? Isn't that just an accounting function calculation?
Well, we provided calculations in our verified answer, as well as in our cross motion. We provided a chart of what had been paid over time, but in terms of what those amounts actually were, the arbitrator never found those amounts. And in fact, in the respondent's brief on page 21, he states that the award made no calculation of what had been paid and expressly left open the question of the balances left on any of these groups of monies.
But I'm asking you, what's the remedy for that?
Well, it's vacating the judgment
and
reversing the order.
And what? How do we get to the end of the game here? Does it go back to the arbitrator? Does it go back to the Supreme Court? What is it? Who does this?
Well,
we do it.
I'm sorry?
Do we do it? How do we get to the end? How do we get to the end?
Well, the governing agreement, the operating agreement states that disputes are to be resolved by the arbitrator. So, to the extent that there is a dispute as to the numbers, the operating agreement would state that it would be resolved by the arbitrator.
So you're asking that this go back to the arbitrator?
Well, that would be.
I'm asking you.
Yeah. Well, disputes under the operating agreement are resolved by arbitration.
Right.
Because there's no real basis for determining precise amounts based on the award as it stands. With respect to the principal amount of the judgment, the judgment awards the principal sum of $442,158, but the arbitrator awarded the total amount of $327,320.25.
Well, that's a function of the attorney's fees. We don't need that to go back to the arbitrator. The arbitrator decided that, right?
Well, part of our cross motion, we sought to vacate that part of the arbitration award, directing the payment of those fees for a couple of reasons. First of all, part of that amount, part of the $327,000 amount, is a sanction for.
Right, we know that.
Right.
We know that, the discovery sanction.
Right, but
right. I'm just trying to have you have an efficient use of your time because it's up.
Yeah, no.
I did. We know
Well,
that.
if it's up, it's up.
Yeah. All right, let's hear from your adversary. Mr. O'Brien?
Good afternoon, Your Honors. May it please the court, John O'Brien, Belayan Nussbaum and Rices for the respondent, Danny Leopold. I want to address directly, Justice Gish, your question of how do we get to the end of this? Right. And respectfully, this is the end of this. This waiver argument, appellants did not bring that up at Supreme Court. Appellants had a proposed judgment in hand that is identical to the judgment that was entered by Supreme Court. And upon reading it, and when respondents asked the court, you should do the accounting this way, you should add this up. The appellants did not ask the court not to do that. They did not say that that would be a modification of the award. They just asked them to do a different sort of.
You're talking about the attorney's fees.
Your Honor, I'm talking about which buckets of money can be repaid. The first issue.
Counsel, what about if the way it was done was not consistent with the findings of the arbitrator, which is the argument your opposing counsel makes? If she had the power to do it, but the argument is made that she did it in such a way that was not consistent with what the arbitrator found in its award.
It was respectfully, Your Honor, I disagree. It was entirely consistent with what the arbitrator found. One thing that's important to note here.
Let me ask you a specific question. Did the arbitrator make specific findings as to whether certain things were or were not paid off at the time of the arbitration?
No, Your Honor. He made findings as to which buckets of money could earn what. He did not have the power because it was neither the claim for arbitration nor the counterclaim as to what had been paid. There are appellants' own spreadsheets that show the millions of dollars they've taken back out of the company. The only question is, the dispute was they were intending to take back at a 12% to 15% interest rate from the outset.
So you're saying he made no determination one way or the other whether anything had yet been paid?
I would look at
some things that seem to indicate otherwise in the wording of the arbitration award.
I understand. I'm sorry, I don't mean to speak over you. There was a slight lag there. I think if you look at R57, the footnote, the arbitrator says remaining principal balance is defined as the respondent's capital contributions less any reimbursement amount that respondents have already received from the company. And there's a similar notation with the note, less any previous payments already made. He specifically emphasized, I'm not making any determination of what's already been paid. Neither party asked him to make that determination. This was actually brought as a fairly straightforward declaratory proceeding.
So you're saying it would be consistent with his award to find, as the court did below, that certain things were totally paid off because he didn't make a finding one way or the other in his language.
That's absolutely correct. And I think it's important to note here that the appellants are fiduciaries of the company that have found to be extensively self-dealing with the company. That's why Mr. Leopold was vindicated on the second part of his claim, which is that he was constructively ousted from management of the company. The appellants are also fiduciaries of the company. They are also manager members of the company. So if they were to do the accounting as the way they urge that it should be done, pay back zero interest debt first, hold back high interest debt for their own personal profit, that is sanctioning a breach of fiduciary duty on the black letter. Courts have found, and Nathanson, which is quoted in our briefs, that allegation sustains an allegation of breach of fiduciary duty by itself. The appellants here are asking this court to mention that, to codify it. If I could briefly address the counsel fees issue, I think it's pretty clear in the award that the arbitrator found separately sanctions for misconduct for $114,000 and an award of counsel fees pursuant to the arbitration agreement. The American Arbitration Rules and this court allow arbitrators to award sanctions for misconduct during those proceedings, and they should be sustained as well.
I just want to go back, Mr. O'Brien, because where in the award did it specifically indicate that the petitioner was going to be awarded the $114,000 figure? Because it only just deals with the $324,000 figure as it relates to counsel fees. That's it.
If you go to R67, paragraph 109.
I know. I don't see it. That's why I asked you.
I find that the claimant is awarded the difference between his counsel fees and respondents in the total amount of $114,000 earlier in the paragraph, because respondents engaged in dilatory conduct throughout the instant arbitration process. Separately from that $114,000 award, you have at the bottom, with respect to the counsel fees pursuant to the arbitration agreement, the claimant is also awarded his $327,000 as the prevailing party. So it is delineated in two separate paragraphs, and there's no reason to read an arbitration award to write out or eliminate one section of it.
Okay. All right, Mr. Juneau, rebuttal?
Yes, Your Honor, if I could just address that last portion there by
Mr. Juneau, I actually have a question for you. I want to go back because isn't it true that, you know, in the court below, you didn't indicate that the award was modified? Really, what you asked the court to do was present certain calculations, to perform certain calculations. Isn't that correct?
Well,
that's a yes or no. I mean, it's so simple.
Yes, we denied their allegations and we asked for a different calculation, correct?
Right. So I'm saying you never said that the award was modified. That's the question. You didn't make that argument below.
Well, no, we're not saying the award is modified. I'm saying that the judgment modifies the award substantially. So, and the judgment did not exist. The final judgment, certainly a signed judgment, did not exist prior to that. With respect to your question to Mr. O'Brien about the attorney's fees, I think the last page of the arbitration award is pretty clear that the total amount is $327, and then it directly.
Let me interrupt because I want to circle back for a minute before I forget my question.
Okay.
Opposing counsel made an argument that what you submitted to the arbitrator was limited, that no one made any arguments to the arbitrator or submitted the issue to the arbitrator of what had or had not yet been paid, whether the mortgage had been paid or any of the buckets had or had not been paid off, and that the arbitrator was making certain limited findings. So we shouldn't take anything from the way the arbitrator worded anything, that the arbitrator made any substantive findings about what had or had not been paid off at the time of the arbitration. What is your response to that?
Well, that is correct. The arbitrator made no specific findings as to what had or had not been paid, which
what's wrong with the court below making those findings, making the findings that the mortgage was paid off at X date and therefore no interest accrued, or whatever findings she did make? If the arbitrator didn't make any of those findings, what was wrong with what the court did below in terms of making determinations and rendering a judgment?
Well, I'm sorry. With respect to the specific amounts, the arbitrator made no finding. The problem with the judgment, though, is it makes factual adjudications with respect to when the mortgage note was satisfied. The judgment states that it was satisfied in March 2013.
So isn't that part of what she had to do? If that issue was not submitted to the arbitrator was not assigned the task of making determinations when things were or not satisfied, why was it inappropriate? Who else but the judge would make those determinations, since the arbitrator didn't make those determinations?
No, the arbitrator made certain factual findings with respect to whether or not the note was satisfied, whether or not the Bakharovs were entitled to a return of their equity.
But didn't he say that wasn't in the scope of what, that was my question to you initially, whether that was in the scope of what the arbitrator was supposed to be deciding or not within the scope of what the arbitrator was supposed to be deciding?
I'm sorry, Your Honor, I was trying to make a distinction. I guess I didn't make it clearly that, yes, he found with respect to certain facts, but not with respect to the amounts. That's the difference. The difference is the arbitrator said that the note was not satisfied, and he said that the equity is to be repaid to the DeBaccaroffs, but the arbitrator made no specific factual findings with respect to the amounts
So
to be
I
repaid.
don't want to beat a dead horse, but I sort of want the answer to this question, which is, was that appropriately put before the arbitrator at the beginning of the arbitration that we want you to make a determination whether or not the mortgage was or was not paid off at the time of the arbitration? That's part of what you should be deciding as part of this arbitration.
Well, it was part of the dispute, part of the arbitration, but the amounts were not specifically put before the arbitrator. Does that answer your question, Your Honor? I'm not trying to be evasive. I'm just saying that the arbitrator, within the context of the arbitration, made certain factual findings, but didn't make findings with respect to certain amounts because he wasn't presented with an accounting.
Okay. Any further questions, Counselor, colleagues? All right, thank you both.
Thank you, Your Honor.
Okay, last case of the day, Napoli Skolnick against Greenwich Insurance.
May it please the court, thank you for permitting me to appear before you today. I'm pleased to be with you here this afternoon. I'm Megan Finnerty, and I represent the appellant and plaintiff below, the law firm Napoli Skolnick, in its claim against its professional liability carriers for their refusal to defend a lawsuit pending in the federal court in Maryland by the Keys law firm. And I know time is short, so I'm going to cut right to it. All three of the appellate issues here, substantive coverage, notice, and the denial of the motion for leave to amend, really all stem from the same fundamental error by the motion court below. And that was this. The motion court looked only at the allegations of the initial complaint in this action and not the allegations in the first amended complaint, in the Keys first amended complaint below, that trigger the policy's coverage. Specifically, the motion court characterized the Keys claim as a breach of contract claim that did not arise from conduct requiring a law degree, without any analysis of the allegations within the amended complaints. This error permeates each appellate issue that I will briefly address. First, on the substantive coverage issue, coverage is triggered when the claims allege an act or omission in the rendering of professional services or in the conduct of any business conducted by or on behalf of the firm in its professional capacity as lawyers. The underlying claim by the Keys law firm, when it was initially filed in October of 2017, was just as the motion court presented it, a breach of contract claim alleging that Napoli Skolnick owed Keys unpaid shared referral fees. That was all it was. However, Keys amended its complaint in February of 2019, and the motion court did not analyze those allegations, and the characterization is no longer a fair assessment. When Keys amended filed the first amended complaint in February of 2019, for the first time, Keys alleged ethical, fiduciary, malpractice, and standard of care violations that implicated the carrier's policies. Specifically,
were they seeking a different relief in the amended complaint, other than but they were seeking additional? What were they seeking that was different from the first complaint?
Yes, Your Honor. So they added 20 some allegations, including
I guess the allegations, but what were they looking for as a result of them?
So throughout the case, they sought a calculation of damages based upon the fact that Napoli Skolnick did not recover in the underlying cases as much money as they expected the court to recover. That at trial, they were still seeking an award through the constructive trust claim back to the subject clients for excessive fees that they say that they alleged were incurred. And and the characterization of their referral fees, what they say they were owed, they asked the court to permit evidence and that Napoli Shkolnik did not recover the amount of fees that they should have, that they did not recover for the subject clients, the amount of settlements that they should have recovered. And this was based on what they characterized as exorbitant and improper expenses, which they then sought to pull out from the referral fees that were recovered. So there were no allegations in the initial complaint of any impropriety or breach of ethical obligations with respect to expenses, for instance, that were incurred in the prosecution of these claims. But with the first amended complaint, these allegations of ethical breaches with respect to the incurring of what they term improper or exorbitant fees in the filing of these 2,174 lawsuits, these allegations make an appearance for the first time in the first amended complaint, and that impacted the relief sought, and it impacted the relief sought all the way through trial. And in addition to the expense issue, they're also alleging that Napoli, for the first time in the first amended complaint, that Napoli Shkolnik did not communicate with the subject clients. Paragraphs 73 and 74 of the first amended complaint, for instance, are new, and that the firms, including Napoli Shkolnik, could not handle the claims that it had a duty to handle, so that they mishandled the subject claims, which impacted the recovery. And they also alleged for the first time a negligence cause of action against Napoli Shkolnik attorney Paul Napoli, which that's not analyzed at all in the below opinion. So on the and so with respect,
wrap it up.
Okay, and this error also impacts the notice issue, right? Because the motion court below says that the notice was given 2 years late, but that's based on the first complaint, which the court and the carriers say didn't establish coverage anyway. So they're saying paradoxically that you should have given notice of a complaint that they say does not trigger coverage. And so because the motion court's opinion is based on that,
we understand your argument. Let's hear from your adversary.
Thank you, Your Honor.
Mr. Shah.
Thank you, Your Honor. May it please the court. My name is Sanjit Shah. I'm an attorney with the law firm Mount Cotton Woolen and Greengrass LLP. We represent Greenwich and Hudson in this appeal. I think it's undisputed that that as originally filed, the complaint that the Keys law firm submitted did not implicate the Greenwich policy because it did not implicate an act by Napoli.
They're not even arguing that. They're talking about the amended complaint. Right.
Thank you, Judge. Thank you, Your Honor. The first amended complaint was filed on February 13th, 2019, according to Napoli Shkolnik, and it appears on page 139 of the record. That amended complaint sought to enforce the same fee-splitting agreements as the original complaint. Therefore, it also does not come within the insuring agreement of the 2018.
Were they seeking any additional damages?
No, Your Honor, they were not seeking any additional damages. There were additional allegations concerning Napoli Shkolnik's charging of excessive fees and its inability to handle cases that it was obligated to handle, but they did not seek to hold Napoli Shkolnik liable for those acts. And in George Mulestock v. American Home Assurance Company, this court held that there was no coverage under an accountant's professional liability policy where there was nothing in the underlying complaint asserting liability against the insured for any of its acts as accountants. And here, there is nothing in the underlying Keys action asserting liability against Napoli Shkolnik for its acts as attorneys. Certainly, the Keys law firm made a lot of allegations against Napoli Shkolnik about how it did not do a good job by its clients.
Were there additional causes of action?
There was an additional cause of action for negligence, but that negligence cause of action was not asserted against Napoli Shkolnik, the law firm that was insured. It was asserted against Paul Napoli and some other individuals. There's no evidence himself is an insured. The person who is and possibly an insured is Marie Napoli. Her affidavit is on page 323 of the record. She is an insured of this of Napoli Shkolnik because she is a partner in the law firm. There's no evidence in the record that Paul Napoli is a partner in the law firm, and because there was no attempt to hold Napoli Shkolnik liable for these misdeeds that are committed vis-a-vis their clients, the duty to defend is not triggered, because the duty to defend, because there is no legal or factual basis on which Greenwich or Hudson would be called upon to indemnify Napoli Shkolnik for policy, because Napoli, the Keys law firm did not seek to hold Napoli Shkolnik liable for this misconduct vis-a-vis the clients. There's reference in the reply brief of Napoli Shkolnik to the trial transcript. We respectfully submit that that should be disregarded. It's not part of the record before this court, nor are some of the other documents that are referred to in the record. And finally, as Justice Kern pointed out, in the previous appeal, the duty to defend is determined by reference to the complaint and the insurance policies, not by what happened at trial. Therefore, we respectfully submit that Judge Bluth correctly determined that there was no coverage under any of the policies. We also respectfully submit that Justice Bluth correctly determined that there was no coverage by reason of late notice. Here, the first amended complaint, according to Napoli Shkolnik, and this appears on page 139 of the record, Napoli Shkolnik argued in the federal court action that the first amended complaint sought to enforce the same fee-sharing agreements as the original complaint. Therefore, under Section 8 of the policies, the first amended complaint must be considered to be a single claim with the original complaint, and therefore must be determined to have arisen at the time the original complaint was filed. And that's on page 62 of the record. Even if the first amended complaint were a separate claim, it was not reported to the carriers until 7 months later, and that's unreasonable as a matter of law. That's SPS and Associates, which we cite in our brief. And finally, I would just like to add that under 3420D of the insurance law, it's very clear that the notice prejudice rule applies only to occurrence policies. It is undisputed that the policies at issue here are claims made policies, and the mere fact that the claims made policies issued by Greenwich and Hudson required that notice be given as soon as practicable does not change those policies into an occurrence policy, and therefore it was unnecessary for Greenwich and Hudson to show prejudice by this 2-year delay in reporting the claim. And I thank the court for its time.
Thank you. All right, Ms. Finnerty, final word.
Yes, Your Honor. Briefly, the fact that the amendment sought new damages, the damages owed to the Keys firm, or alleged to be owed to the Keys firm, were directly impacted by these ethical breaches that they're raising for the first time in the first amended complaint. And when the claims fall under the plain language of the policy requiring that the claim arise out of the law firm's professional conduct because they arise out of an insured's conduct in obtaining settlements or referred clients. And I direct the court to Napoli, Kaiser, and Byrne versus Westport Insurance Company, a second Southern District of New York case 295 F sub second 335. And separately, opposing counsel quoted me multiple times in my opposition to the motion for leave to amend to file the first amended complaint, in which we said it all related back to the same referral agreements. I lost that motion. The carrier's duty to defend is exceedingly broad. The plaintiff was permitted to bring that first amended complaint, to file those first amended complaint, making all of these new allegations. And under New York law, the carriers were required to defend those allegations, which dealt with our the Napoli Shkolnik's professional obligations as attorneys. And finally, the case law that counsel cites in support of whether or not prejudice was required for late notice relates to claims made and reported policies. Respectfully, Hudson and Greenwich could have said that their policy required you to report the claim within that policy period, but that's not what the language of this policy said. It said as soon as practicable. So under the New York insurance law that we cite in our briefs, the claim had to be reported within that policy period or within any renewal, which is exactly what happened here. And finally, the notice issue does not impact the motion for leave to amend the complaint for Napoli, Shkolnick and Associates. It's undisputed that Napoli, Shkolnick and Associates was not added to the underlying action until the day before we gave notice of this claim. So there is no dispute that notice as to Napoli, Shkolnick and Associates was timely. And the only underlying basis for the denial of the motion for leave to amend was that there weren't allegations, substantive allegations related to the conduct of law firms. And with the record that we've given you with respect to the negligence claims and everything else, clearly that triggered the coverage of the policies. And with respect to Paul Napoli, there is evidence in the record that Paul Napoli is alleged to have controlled and operated Napoli Shkolnick, the policyholder, and isn't insured under that policy. That the plaintiff alleged Paul Napoli controlled and operated Napoli Shkolnick, the policyholder, and that's the evidence in the record. And if there's not further evidence in the record, it's because this motion was brought prematurely and under the broad duty to defend. And the standard on this type of motion where the documentary evidence has to irrefutably obviate coverage under CPLR 3211A1, that would not be a basis to grant that motion. And so we would request reversal.
Okay, thank you. Thank you both. Thank you both for your patience. This session of the Appellate Division is now closed.